ಇದುವರೆ ಆದ್ರೂ ಬರಲ್ಲ ಬರದೇ ಇಲ್ಲ. ಇವ್ರನ್ನ ಬೇರೆ ಕಾಯ್ದಿದ್ದೀವಿ. ಯಾರು ಬರ್ತಾರೆ ಬರಲ್ಲ. ಇದೇ ಕೆಲಸ ನಮಗೆ ಬುರ್ಕ ಕೆಲಸನೇ ಆಗೋದು. ಇದು ಕಳ್ಸಿದ್ರೆ ಆಧಾರ್ ಕಾರ್ಡ್ ವಾಟ್ಸಪ್ ಅಂತ ಸದ್ಯಕ್ಕೆ ವಾಟ್ಸಪ್ಪು ಅವತ್ತು ಹೋಗ್ಬೋದು ಜೆರಾಕ್ಸ್ ಇಟ್ಕೊಂಡು ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಪಿ ಎಸ್ ಕೆಲೆ ಕೊಟ್ಬಿಡೋಣ. ಶುಕ್ರವಾರನೇ ಪಿ ಎಸ್ ಮೇಡಮ್ ಹತ್ರ ಕೊಟ್ಟಾಗಿರೋಣ. What is it? What is it? ಮಾಲಾ ಮೇಡಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಟೈಪಿಂಗ್ ಇದು ಏನೋ ಸ್ಟೆನೋಗ್ರಾಫರ್ಸ್ ಬೆಳಗ್ಗೆ 10:25 ಬರ್ತಾರೆ. ಮೊನ್ನೆ ಬಂದಿರಲಿಲ್ಲ ನೀವು. ಕರ್ಕೊಂಡ್ಬರ್ತಾರೆ ಮಿಸ್ ಆದರೆ. ಮೊನ್ನೆ ಮಿಸ್ ಆಗಿಲ್ಲ ಸೌಮ್ಯ. ನಾವು ನಿಮ್ಮನ್ನು ನೋಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾ? ಅವ್ರು ಬಂದಿಲ್ಲ, ಇವ್ರು ಬಂದಿಲ್ಲ, ನಮ್ದನ್ನು ಓದೋರು ಯಾರಿಲ್ಲಿ? ವೈಬ್ರೇಷನ್ ಮಾಡ್ತೀರಾ, ಎಲ್ಲ ಬೇಗ ಬರ್ತಾರೆ. ನೀವು ಮಾತ್ರ ಆರಾಮಾಗಿ ಬರ್ತೀರಾ. ಸುಮ್ಮನೆ ರೀ, ಅದು ನೆನ್ನೆಗಾಯ್ತು. ಅದಕ್ಕೂ ನಮಗೂ ಸಂಬಂಧ ಇಲ್ಲ. ನಿನ್ನೆ ನಾವು ಎಷ್ಟು ಬೇಗ ಕಳಿಸಿದ್ವಿ ಅಲ್ಲ, ನಿನ್ನೆ ನಾವು ಎಷ್ಟು ಬೇಗ ಕಳಿಸಿದ್ದೀವಿ. ಇವತ್ತು ಲೇಟಾಗಿ ಕಳಿಸ್ತೀವಿ. ನೀವು ಗುಬ್ಬಿ ಯಾವ ಕಡೆಯಿಂದ? ಕುಕ್ಕೋಂಗೆ ಕೆಣಕ್ತಾರೆ. ಈಗ ಸೌಂಡ್ ಸುದ್ದಿಗೆ ಯಾಕೆ ಹೋಗಲ್ಲ ನಾವು? ಅದು ಬೆಳಗ್ಗೆಯಿಂದ ಇಲ್ಲೇ ಇರ್ತಾರೆ. ಕರೆಕ್ಟ್. ಈ ಕಡೆ ನನಗೆ ಕಾಣಿಸಲ್ಲ, ಆ ಕಡೆ Any memos?
The advantage of interim order not releasing the farmers fund, my lords. Kindly have it tomorrow, my lords. Yes. Tomorrow, my lords.
Yes. 2:30 ಇಲ್ಲ. 2:30 ಇಲ್ಲ. File. No. Tomorrow. What is to be done, sir? No end of the list business. Next. Any adjournment? List 1, page 4, serial number 11 to 13. Serial number 13. Yavdu serial number? This one 13. Prakash Reddy. Yes. Also for the petitioner place for time. Next. Page 5, serial number 14. Page 6, serial number 15 and 16. Page 7, 17 to 20.
18 lordship. Serial number 18 for petitioner. Since 2 times.
Lord, this is my lord, infructuous matter, my lord, to election held on 28/8, my lord. Nothing several for consideration.
Order. Wait, man. Infructuous idre sumne dispose ಮಾಡೋದು.
Serial number 20 minutes.
I am
filing withdrawal memo minutes.
Counsel for the petitioner memo 20. Seeking permission to withdraw the petition. Memo is placed on record, petition dismissed as withdrawn. Next. Page 8, serial number 21 to 23.
My lordship, 23, my lordship, for the state, on the last date of hearing, my lordship had asked for the whether the society has been existent. There is a resolution is passed in the year 94, society is not in existence. They want to find out something about that, the committee has been formed, my lordship, with, so.
Wait, it is posted finally, let me see. Wait for some.
Page 1, serial number 1.
Paper petition.
List number 2, my lord. List number 2, serial number 10, my lord. I filed the application, my lord. 2 days accommodated, my lord.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್
ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ. ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ, ಟೂ ವೈಫ್ಸ್ ಇದ್ದಾರೆ. ಅವರು ಹಾಕುವಾಗ ಅಪ್ಲೆಂಟ್ ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ಫಸ್ಟ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ಸ್ ರೆಡಿ ಇದೆ. ಅವ್ರೇನೋ ಹಾರ್ಟ್ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ನೋಡೋಣ ವೆದರ್ ಯು ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಎನ್ ಅಪ್ಲಿಕೇಶನ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ನು ಫೈಲ್ ಮಾಡಿಲ್ಲ. ಸೈನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಅದೊಂದು 2 days accommodated ಮಾಡಿದ್ರು.
ನೋಡೋಣ ಸರ್, ಅದು ಬರ್ಲಿ, ಅದು ಏನಿದೆ ಅಂತ ನೋಡೋಣ.
My lord, serial number 1.
One.
Madam, 1 week. Madam, my lord, 1 week time ಬೇಕು. ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ.
Serial number 2, P.D. Sandesh, H.M. Basuraju, K. Anand.
Appear for the
Petitioner comes.
Some office note have already been clarified by your lordship's last occasion.
Seven and 11 are the ones. 7 ಬಂದಿಲ್ಲ. 9, 10, 12 and 17. Hmm. 7 and 11 are one and this. How did they ಬಂದಿಲ್ಲ? Held to be sufficient, 11. What about 10, 12, 9, 9? Who is representing are 9, 10, 12 and 17? Read. 9, 10, 12 and 17. Awaiting notice. Yes. Certification of office objection raised.
I think they are not necessary. to
They are
appear.
not necessary.
They are only formal practice.
They are parties in the dispute.
They are
in the court.
parties in the dispute proceedings.
ಇದರಲ್ಲಿ
Moreover, my lord, the writ
7
petition
and
itself is
2,
not
11,
maintained
1 and
because
16.
the interim order passed, the petitioner has filed the interim, challenged the interim order passed by the respondent number 3.
In
They have to
election
file a
dispute.
revision petitions, and moreover, election is already completed. The similar
7
cases, your lordship,
and 7.
permitted them to raise the dispute under section 70,
The election was held
26/6/2025,
26, 6.
6/2025.
ಮತ್ತೇನಿದೆ?
As far as 11.
They
is
are
concerned,
permitted to cast the vote, they casted vote, I think.
Their
and
vote
they are
is kept in
contested also.
separate box. In the similar matters, your lordship directed to declare the result without counting the vote, and they permit.
It won't stand on that.
Now,
vote. It's
now
a-
the
it's on a-
result is not yet declared.
No, man.
Result is not yet declared, and it's a election petition which they have filed before, filed in which an interim order is made. As far as
Now,
11,
what is
11
the-
is concerned,
What is the
Please,
prayer you
madam.
are seeking?
your lordship may, as far as respondent number 11 is concerned, your lordship may kindly permit me to delete him because serial number, respondent number 7 and,
Asking you, what is the relief now you are?
please, ma'am. Relief
Set aside
sought
the
is
impugned order 29/4/2025.
Please.
Is that order?
annexure F, my lord. Page for, typed copy is at
43.
page
Okay,
46.
This prayer B does not survive for consideration now.
Please, mother.
Prayer B.
Please, mother.
Include your name.
This election is already over.
Yes, it is included, but it depends on the result of the petition.
Now this annexure F is passed by
Annexure
respondent number
F
2.
is passed
Assistant
by
registrar, third respondent.
Assistant Registrar of Cooperative Societies in a election dispute filed by the
Under which section?
respondents
Under which section?
under section 70.
Seventh respondent.
70. It
Please.
is an appealable order.
Yes,
Yes, it is an
Revision
appealable
has-
order.
It
There
is
is
not an
a,
appealable order.
It
it's
is
an
a revision
interim
is
order
provided.
passed.
Person, wait for
It's
some.
an. But your lordship may kindly see what actually are the factual aspects of this case are. a meeting for electing a delegate is called.
Sir,
There-
whatever may be the
No,
facts of the
just-
case.
just
You
2
can
minutes.
definitely raise the.
Just
propriety.
2 minutes, my lord, just 2 minutes. Meeting was called. There was a contest for being elected as a delegate. There was a contest.
Yes.
Petitioner and fourth,
Seventh.
seventh respondent were the contestants. In that, vote ballots were issued, vote was cast. One of the ballot, admittedly, vote was not done in the box provided for that. That vote was rejected.
Yes.
Respondent number 7 says, though it was not within the box given there, it was just above the box against my name, therefore it should have been counted in my favor, is the case made out by them.
Yes.
On that, they file a dispute under section 70.
Yes.
As far as dispute under section 70 is concerned, my lord, in respect of matters pertaining to election, the same can be filed only after the declaration of the result. Your Lordship may kindly see section 70. Kindly go to section 70, capital A. Period of limitation.
ಕ್ಯಾಪಿಟಲ್ ಎ ಇದು ಯಾವ್ದ್ರಿ ಇದು 2021 ಪ್ರತಿಯೊಂದು ಹಳೆಯದು ಏನಿದೆ ಪ್ರತಿದಿನ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅದನ್ನೇ
70 capital A.
70
70.
ಕೊಡಿ
70 capital A, period of limitation.
Yes.
Please, no dispute under section 70 shall be entertained unless it is referred to the registrar within 6 years from the date of cause of action. Provided that dispute relating to the election of member, president, vice president, or other office bearer shall be referred to the registrar within 30 days from the date of declaration of the result of election.
Yes.
Now, this was in respect of delegate being sent for the election now. DCC Bank, Mysore.
Yes.
The results of that election are yet to be announced. At that stage itself, section 70 dispute is filed.
Yes.
In that, your Lordship may kindly see his petition.
No, that is your contention is that the dispute does not lie because no cause of action has arisen.
Cause of action would come a little later,
Correct.
not at that stage. Your Lordship
What
may
is the
kindly
order?
see page
What is the impugned order?
37 bottom. One ನಿಮಿಷ ತೋರಿಸ್ಬಿಡಿ.
Annexure F ಏನು?
Annexure F is the interim order passed. ಇದು
Is that
page
order?
37 bottom, our petition. Para 3.
Come to
Page-
annexure F. Annexure F.
ಅಲ್ಲ, F ನಾನು ತೋರಿಸ್ತೇನೆ, ಒಂದೇ ನಿಮಿಷ ಇದನ್ನ ನೋಡಿ.
ಸುಮ್ನೆ unnecessarily waste of time.
Please
Next,
kindly go to page, typed page 46.
46. Yes.
ಪ್ರಕರಣವನ್ನು ಕರೆಯಲಾಯಿತು. ವಾದಿ ಹಾಜರು, ವಾದಿ ಪರ ವಕೀಲರು ಹಾಜರು. ವಾದಿ ಪರ ವಕೀಲರು ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ಕಲಂ 70 ಅಡಿ ದಾಖಲಿಸಿ 15/4/25 ನಡೆದ ಆಡಳಿತ ಮಂಡಳಿಯ ನಡಾವಳಿಯನ್ನು ರದ್ದುಗೊಳಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಮುಖ್ಯ ಅರ್ಜಿಯ ಜೊತೆಗೆ 71(3) ಅಡಿಯಲ್ಲಿ ಮಧ್ಯಂತರ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೂ 15/4/25 ಆಡಳಿತ ಮಂಡಳಿ ಠರಾವಿಗೆ ತಡೆಯಾಜ್ಞೆ ಕೋರಿರುತ್ತಾರೆ. ಪ್ರಕರಣವನ್ನು ಕೈಗೆತ್ತಿಕೊಳ್ಳಲಾಯಿತು. ವಾದಿಪರ ವಕೀಲರು ಮಧ್ಯಂತರ ಅರ್ಜಿಯ ಮೇಲೆ ತುರ್ತು ವಿಚಾರಣೆ ಕೋರಿ ವಾದ ಮಂಡಿಸಿರುತ್ತಾರೆ. ಆಲಿಸಲಾಯಿತು. ಮಧ್ಯಂತರ ಅರ್ಜಿಯ ಜೊತೆ ಸಲ್ಲಿಸುವ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಪ್ರತಿವಾದಿ ಒಂದರ ಸಂಘದಲ್ಲಿ 15/4/25 ನಡೆದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ಠರಾವಿನಲ್ಲಿ 1ನೇ ಅರ್ಜಿದಾರರು ಮತ್ತು ಸಂಘದ ಅಧ್ಯಕ್ಷರ ಸಹಿಯು ನಡವಳಿಕೆಯು ಪೂರ್ಣಗೊಂಡ ನಂತರ ಕೊನೆಯ ಭಾಗದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ವಾದಿ 1 ಹಾಗೂ ಅಧ್ಯಕ್ಷರು ಇವರ ಸಹಿ ಇಲ್ಲದೆ ಇರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 15/4/25 ನಿರ್ಣಯಕ್ಕೆ ಸ್ವಾಭಾವಿಕ ನ್ಯಾಯ ತತ್ವಗಳಡಿ ತಡೆಯಾಜ್ಞೆ ನೀಡುವುದು ಸೂಕ್ತವಾಗಿರುತ್ತದೆ. ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ಣಯವು 1ನೇ ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿ 1ರ ಸಂಘದ ಅಧ್ಯಕ್ಷರ ಸಹಿ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಊರ್ಜಿತವಾಗತಕ್ಕದ್ದಲ್ಲ ಎಂದು ಪರಿಗಣಿಸಿ 15/4/25 ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ಣಯಕ್ಕೆ ತಡೆಯಾಜ್ಞೆ ನೀಡುವುದು ಸೂಕ್ತ ಎಂದು ಕಂಡು ಬಂದ ಕಾರಣ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ. ಮಧ್ಯಂತರ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಪ್ರತಿವಾದಿ 1ರ ಸಂಘದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯ ನಿರ್ಣಯಕ್ಕೆ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ತಾತ್ಕಾಲಿಕವಾಗಿ ಮಧ್ಯಂತರ ತಡೆಯಾಜ್ಞೆ ನೀಡಿ ಆದೇಶಿಸಿದೆ. ಈ ಆದೇಶವನ್ನು 21/4/25 ನೀಡಿದೆ. ಉಭಯತರಿಗೂ ನೋಟಿಸ್ ನೀಡಲು ತೀರ್ಮಾನಿಸಿ ಮುಂದಿನ ವಿಚಾರಣೆಯನ್ನು 26/5/25 ಮುಂದೂಡಲಾಯಿತು. Now your lordship may kindly go to page 37.
This is the order under section 71.
71(3) interim order.
Revision is provided under.
Revision is provided under 107.
Yes.
Subject to the provisions of section 108A, tribunal may suo motu or on application of any person aggrieved call for and examine the record of any proceedings in which an appeal lies to it for the purpose of satisfying itself as to the legality, propriety of any decision or order passed, and if in any case it shall appear to the tribunal that any such decision or order should be modified, annulled or revised, tribunal may pass such order thereon as it may deem fit.
Can very well
There is a revision that I myself stated.
Yes.
The situation was, as the elections were immediately ahead, an interim order of stay was issued by which the person who has filed the dispute did not get any benefit.
Yes.
It was not to his benefit also. At the same time, a vote of the society would have been missed. I only bring to your lordship's notice para 3 at page 37. Para 2, they say meeting notice was issued, it was served on them. Then para 3. ಸದರಿ ಮೈಸೂರು ಮತ್ತು ಚಾಮರಾಜನಗರ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಬ್ಯಾಂಕ್ ಲಿಮಿಟೆಡ್ ಮೈಸೂರು ಇವರ ನೋಟಿಸ್ ಮೇರೆಗೆ 1ನೇ ಎದುರುದಾರರ ಸಂಘವು 15/4/25 ಅರ್ಜಿದಾರರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ನಿಗದಿಪಡಿಸಿತ್ತು. 1ನೇ ಅರ್ಜಿದಾರ ಹಾಗೂ 2ನೇ ಅರ್ಜಿದಾರರು ಪ್ರತಿನಿಧಿಯಾಗಲು ಸ್ಪರ್ಧಿಸಿದ್ದರು. His presence is not denied. On the other hand, he says he attended, contested. ಗುಪ್ತ ಮತದಾನದ ಮೂಲಕ ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿಯನ್ನು ಆಯ್ಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಿ ಗುಪ್ತ ಮತದಾನವನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ದೇಶಕರು ಮಾಡಿರುತ್ತಾರೆ. 1ನೇ ಅರ್ಜಿದಾರರಿಗೆ 5 ಮತಗಳು, 2ನೇ ಅರ್ಜಿದಾರರಿಗೆ 6 ಮತಗಳು ಬಂದಿರುತ್ತವೆ. ಆದರೆ 1 ಮತವನ್ನು ಅಸಿಂಧು ಎಂದು ಪರಿಗಣಿಸಿರುತ್ತಾರೆ. ಆ 1 ಮತವು ಚೌಕಟ್ಟಿನ ಸ್ವಲ್ಪ ಹೊರಗೆ ಮತದಾನ ಮಾಡಿರುವುದರಿಂದ ಅದನ್ನು ಅಸಿಂಧು ಎಂದು ಪರಿಗಣಿಸಿರುವುದು ಕಾನೂನಿಗೆ ವಿರುದ್ಧವಾಗಿರುತ್ತದೆ. ಆ 1 ಮತವನ್ನು ಪರಿಗಣಿಸಿದರೆ 1ನೇ ಅರ್ಜಿದಾರರು ಹಾಗೂ 2ನೇ ಅರ್ಜಿದಾರರ ಮಧ್ಯ ಸಮಬಲವಾಗುತ್ತದೆ, ಫಲಿತಾಂಶವು ಡ್ರಾ ಆಗುತ್ತದೆ. This is his allegation in the plaint. I am not talking about right and wrong of it. Now kindly see order annexure F. Order annexure F is passed only on the ground the person who filed the dispute, that is respondent number 7, and the president have not signed at the end. If someone, after having lost in the election,
I understood. Can you not raise this dispute in
I
the
can
revision?
raise it. The situation when I came,
Only question why you have not invoked
the,
section
the time when I came here,
on merits of the case, I am hearing this.
not merits ಅಲ್ಲ, ನಾನು merits ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಆವಾಗ elections were looming large.
Yes,
Therefore,
you justified at that point of time, but not now.
not now.
Yes, that is what they are saying.
Having come up with
No,
this
no,
case,
no.
again party going to
No,
tribunal
no,
or
no.
before the first respondent.
No, I am against assuming jurisdiction over any quasi judicial authority. No, there are, that is, those are the statutory remedy available.
Continue the interim order for a period of
ಅಷ್ಟೇ
20
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
For 20 days, I will do the case.
ತಗೊಳ್ಳಿ. Third one, senior advocate for the petitioner and senior advocate for so and so. ನೋಡೋಣ interim order ಏನಿದೆ ಕೊಡಿ. Interim order ಏನಿದೆ. Yes. That will be kept separately. Yes.
My learned friend is saying if the word is constituted, they are not held to the elections for constituency. Board constitute ಆಗಬೇಕು, ಇನ್ನು ಐದು constituency election ಮಾಡಬೇಕು. There is no such urgency. The submission that is being made is actually not correct.
No, if it is the interim order is extended for a specified period. What is the? Correct, sir. Correct. No, whether if this interim order goes, whether you are able to constitute the board. Election declare ಆದ್ರೆ ಅಲ್ಲ.
Already in 2 constituencies, already permitted to declare the result. Then it will board constitute.
Board constitute ಆಗೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ ಇನ್ನು 4-5 constituency election ಮಾಡಿಲ್ಲ.
Election ಮಾಡಿದ್ರೆ ಪೂರಕ್ಕೆ ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ.
4 ಮಾಡಿಲ್ಲ.
20 so and so. Then it comes, then it AGA for respondent number so and so, and then it comes to so and so, then senior advocate for so and so. Submit in unison that the impugned order produced as per annexure F is passed under section 71(3) of KCS Act, and the revision is provided under section 107. The same is not availed by the petitioner. The senior advocate for the petitioner considered this position and contended that since there was an urgency in the matter, in view of prayer B, small b, within bracket, the petitioner had approached this court. Next part. Now, admittedly, the election to respondent number 5 society is already held on 26/6/2025. In view of the interim order passed by this court, the order dated 24/6/2025, the petitioner was permitted to cast his vote.
But permit me to leave, my lord, I have to go.
Yes, sir, yes.
I'm sorry.
Permitted to cast his vote. Permitted to cast his vote in the election, and accordingly, he has cast his vote. The vote cast by the petitioner is ಎಲ್ಲಿದೆ ಅದು ಸೆಪರೇಟ್ ಆಗಿ ಇಡಬೇಕು ಅಂತ ಎಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ? participate in the election, considering that respondent himself is not eligible to participate in the ensuing election scheduled to be held on 26/6/25, no serious prejudice would be caused to him if the petitioner is permitted to vote. Accordingly, pending disposal of this petition, respondent number 6, returning officer, is directed not to act upon the interim order of respondent number 3 and permit the petitioner to participate in the elections of respondent number 5 scheduled to be held on 26/6/25. This shall be subject to the result of this writ petition.
Actually, there was no prohibition for announcing the result.
Correct.
They have not done it. Subject to result.
ಅಷ್ಟೇ ಏನಾಯ್ತು cast his vote and it is he has cast his vote. It is held that the participation of the petitioner in the election shall be subject to the result of the writ petition. Next, in view of the above, prayer B sought in the petition is rendered infructuous. Regarding prayer A seeking to quash nature F, the petitioner is having ultimately statutory remedy under section 7 of preferring a revision. Under such circumstances, I do not find any reason to entertain the petition. The petitioner is at liberty to invoke section 107 if he is advised to do so. Aste.
The interim order.
The interim order already passed shall be enforced for a period of 2 weeks from today. 2 weeks from today.
My lord, the out of 19 posts, my lord, the elected directors are 16. And out of 16 posts, my lord, 13 regarding the 13 posts is concerned, there is an interim order of this honorable court. Election was held only in respect of the 3 posts. There is an interim order of the 3 posts. Therefore, election was held on only 13 posts, my lord. If already the 10 post result already declared, in 2 posts recently your lordship permitted to declare the result. If this honorable court permitted in this case also, my lord, we will declare the result, then board will constitute, my lord. Otherwise,
Sir, there was no prohibition. ನಾನು ಅದಕ್ಕೆ ಎಂಟೈರ್ ಆರ್ಡರ್ ಓದಿದ್ದೇನೆ.
That's what, my lord. Since the election ಇತ್ತು ಅಂತ
ಸುಮ್ಮನೆ ನೀವೇ ಅನ್ಕೊಂಡಿದ್ದೀರಿ.
I am permitted to declare the result, then
ಈಗ ನಾವು ಅದಕ್ಕೆ ಏನು ಮಾಡಲ್ಲ. You can interpret in your own way.
Please.
ಅಷ್ಟೇ. Interim order granted earlier is extended.
That's my
please, my lord.
ಎಲ್ಲಿದೆ ಆ ರೀತಿ?
Illa, but since the last word is the result, this shall be subject to the result of the writ petition.
Whatever the result, is subject to the result of the.
As for in view of the dismissal, may be permitted, disposal of the writ petition, I may be permitted to declare the result. Otherwise, my lord.
ಅದು interim order 2 weeks ಬೇಡ. In view of the above, respondent number 5
bank.
5 is permitted to declare the result of the election, which shall be, of course, subject to the result of the revision that may be filed by the petitioner. Yes.
Please.
That's my IA may be allowed, my lords. I have filed a impleading application, my lords, in the last occasion.
Now they want to exclude my vote. That's what they are asking.
Hardly, sir, that will be subject to the review. ಅಷ್ಟೇ.
Last sentence delete ಮಾಡಿ. ಮೊದಲೇ ಇದೆ correct. How they understand it, let them understand. ಯಾಕಂದ್ರೆ ಈಗ ಅವರು they will be doing it.
They will declare the result without counting your vote. And your vote will be kept separately, and that will be subject to the result of the revision.
Please, ma'am.
ಅದೇ ಮಾಡಿದ್ದೀನಿ. Subject to the result of the revision. ಅಂತದಿಲ್ಲ, ಬಟ್ ಅವ್ರು ಮಾಡಿಲ್ಲಲ್ಲ. ಅದು that will be. Do you mean to say they could have declared the result? ಈಗ ಮಾಡ್ತಾರೆ ಬಿಡಿ. ಏನಿಲ್ಲ. ಬೇಡ. Nothing. ಅದೇನಿಲ್ಲ.
My IA may be allowed, my lords.
ಯಾಕೆ?
Impleading application.
ಹೋಯ್ತಲ್ಲ, disposal
Please,
ಹೋಯ್ತಲ್ಲ.
lords.
Way of disposal of writ petition IA 1 of 2025 also stands disposed of. Other notice to respondent number 9, 10, 12 and 17 is dispensed with at the request of the counsel for the petitioner. ಸರಿ ಆಯ್ತಲ್ಲ? ಏನು ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಸರಿ ಆಯ್ತು. Next.
Number 3.
I am for respondent number 1, my lord. It is an appealable order under section 46 of the Karnataka Savarda Sahakari Act. On 2 occasions for same ground only.
Yeah.
Last occasion also it was heard and it was passed over, Your Lordship. So only for clarification it was listed.
Counsel for the petitioner is absent, no representation. Order sheet dated 18/11/2025. Reads as under. Even on the previous date of hearing, that is on 8/4/2024, there was no representation. In view of your work, the writ petition is disposed of. However, the petitioner is at liberty to invoke section 46 of Karnataka Savarda Sahakari Act 1997 in accordance with law, if he is advised to do so. Yes, disposed of.
Please.
Bill number 4, A. Vijay Sai.
In view of disposal of writ petition, IA 1 of 2024 stands disposed of.
Now we have removed the office objection.
And what is the prayer?
Challenging. Annexure, my lord.
Rushing annexure.
Application rejected, my lord. Order 16 and rule 1 and 2 of CPC.
Passed by. Annexure. Witness is summoned to give evidence. Stella.
Please.
Why you are opposing? Yogya Vallavan.
Please, application is rejected, my lord.
Yes. Issue notice and Learned counsel for the petitioner submits that pursuant to the permission given by this court, he has complied with all the office objections. That is clear. Next, counsel for the petitioner has filed an application under section 7 1 of 2025 looking to recall the order dated 4/11/2025 dismissing the 4/11. Dismissing the petition that default by the settlement for the reasons stated so IA 1 of 25 is allowed. Order dated 4/11/2025 is set aside. Writ petition is restored on file.
R1, my lords.
Notice for
R1 only.
number 1.
2 and 3, my lord. Notice should go.
Issue notice to respondent number 2 and
2 and 3.
Bill number 5, Narasimha Rajesh.
This of the service of notice.
Filed application for vacating stay.
I am for the petition, my lord.
Yes.
May I please? I have the dispute challenging the.
Who is representing respondent number 1?
One Sanal. I pay for this.
Parents Agita.
But I am for the respondent number 3.
Yes. Yes, you are ready to address arguments on merits?
Yes, my lord. I have challenged the resolution dated 23/8/22, my lord. That has been, the dispute has been rejected, dismissed on 6/2/25. Wide annexure B, my lord.
No,
In
who
page
is the
number
petitioner?
31.
Who is
One
the
of the director,
petitioner?
my lord. One of the director.
Of?
Respondent
Of first respondent.
Ah. Then what is your grievance?
And immediately I have preferred the appeal before the learned KAT on
Sir, you have to
9/2/25.
tell me. You have to tell me the facts of the case. You are one of the directors
Yes.
of respondent number 1 society.
Yes, my lord. In the,
what is your grievance?
I have resigned for the non-organized, organized management by the other directors and the president. And that is actually under frustration I have given the resignation initially. So I am contending that it is not it has been accepted after 50 days. In the meantime, they have issued notice to attend the meeting also. On
When it was accepted?
On 23/8/22, my lord.
In the meantime, you are asked to attend the meeting.
Yes, my lord. That is why I was under the impression that that has been not accepted. And
but you have not withdrawn the.
Yes, my lord. I did withdraw the resolution. Resignation.
Yes.
However, that is on 23/8 that has been accepted, which I have challenged by filing a dispute, my lord. On 6/2/25, the my dispute has been dismissed. And as on 6/2/25, I have been continued as a director in view of the interim order.
Yes.
On 9/2/25, I have preferred the appeal before the learned KAT, my lord.
Yes.
Along with the appeal, I have also sought for stay of the resolution dated 23/8/22. Since there was a caveat, the notice has been issued to the respondent number 1 society.
Yes.
And they have appeared through their learned advocate. And my lord, kindly see page number 43. Page number 43, my lord. First line, heard orders on IA number 1. That was on 19/2/25. The learned KAT heard both the petitioner as well, appellant as well as respondent, and posted for orders on 21/2/2025.
Yes.
In the meantime, on the same day, 21/2, my lord. On 19/2/25, on the same day, when the matter has been heard on IA number 1, they have appointed this respondent number 3 as the director in my place.
Was there any interim order?
On that day, there was no interim order, but actually that was heard on the same day, my lord. It was within the knowledge of the respondent society.
Maybe there, but there was no interim order, sir.
But my lord,
who was appointed as the director?
Third respondent, my lord.
Co-option.
Respondent number
respondent.
3.
Yes, my lord.
Yes.
My IA has been allowed on 21/2. Kindly see page number 47, my lord. Order on IA number 1, stay application. An order of stay is granted, operative portion, my lord. An order of stay is granted,
Yes.
staying the operation and further action. The word is very clear. Further action on the decision made in issue number 12 on 23/8/2022 by the first respondent
Yes.
until the next date of hearing, which is still continued as on today.
Yes.
That
Yes.
order. And 19/2 they have passed the resolution, and I have filed IA number 3 challenging that resolution, my lord. And in the meantime, the third respondent also filed the impleading application. On the same day, both the IAs have been allowed. Page number 52, your lordship may kindly see. My application, IA number 3, has been allowed on 11/7/2025. Agreed by that order, IA number 1 and 2, this third respondent challenged both the IA orders on IA before this honorable court, my lord. Page number 53 is the judgment passed by the coordinate bench of this honorable court. Your lordship may kindly see page number 54. Yes. Page number 54, oral order heading, my lord. The petitioner has challenged. The petitioner has challenged an order dated 21/2/2025 passed by the Karnataka so and so on IA number 1 in appeal number so and so, as well as the order dated 11/7/25 passed by the tribunal in appeal number 35 on IA number 3. So the third respondent challenged both the IAs, my lord. Both the IAs they have challenged, and that writ petition allowed in part, my lord. Para number 9, page number 59. Accordingly, this writ petition is allowed in part. The impugned order dated 11/7/25 passed by the Karnataka Appellate Tribunal on IA number 3 filed by the respondent number 3 herein in appeal number 35/25 is set aside. The tribunal is directed to provide an opportunity to the petitioner herein to file objection to IA number 3, and after hearing him and the respondent number 3 herein may pass the appropriate orders. But order on IA number 1 is not disturbed. It has been continued, my lord.
Yes, that is staying the operation of the further proceedings.
Yes, staying the resolution, earlier resolution, my lord.
Yes.
The matter has been remanded, and the IA number 3 has been reconsidered by the learned KAT. And the learned KAT rejected my application as per Annexure F. Kindly see the page number 77, my lord, in the last but 3 lines from the below, 4 line. Para number 26, last 4 lines from the page number 77, my lord.
Page number
77. Para 26. 4th line from the bottom. No doubt it is true that the resolution dated 19/2/25 is subsequent development after filing of the appeal, but nothing prevented the appellant from filing the amendment application. Therefore, on this count itself, the interim application for stay is not maintainable. That is one of the ground, my lord. Now, my humble submission, the interim order on IA number 1 is challenged. It has been confirmed by this coordinate bench of this honorable court, and it has been interim order has been continued. And as per order on A number 1, it is very clear all the subsequent events has been stayed by the
But
Honorable Court.
appointment, the option of respondent number 3 was much earlier to the order.
But actually, Lordship, kindly see, the KAT has
Subsequently,
heard the
they have
matter.
not done anything. Yes,
But in the
no
order
order was
itself,
passed regarding the co-option of respondent number 3.
yes, my lord. But in page number 47, it is very clear in the order on IA number 1. Further action on the decision made in issue number 12 on 2380.
23, my lord. 23 of 74, page number. It has been discussed by my lord. The disputed fact emergo from, sorry, undisputed fact.
In para 23, there is reference to the co-option of respondent
Also, my
number
lord, 24, also, my lord, the extract, my lord, 28A.
3. Taking into consideration the situation,
25 and
the
26.
order was came to be passed.
Please, my lord. 25 and 26 also, my lord. Within 15 days.
Yes. No, that is for the, it is yet to be decided by the KAT, still pending.
Please.
Yes. No, you have gone with the appeal that is pending before the KAT. No interference is required.
My lord, otherwise the order on IA number 1 will become infructuous. It is a contradictory to both. And my lord, kindly see.
Already it has become. Already it has become, sir. Already it has become.
No, my lord, it has been continued as on today. And my lord, kindly see, same non-judicial member has passed both the orders. And only the judicial member has been changed. And furthermore, your lordship, kindly see, it has been, the order is very clear. Subsequent events also stayed, all the events pursuant to the resolution.
Subsequent, yes, sir. Is it your contention that subsequent to passing of the order, they have co-opted respondent number 3? No.
No, my lord,
Much earlier to that.
the conduct of the respondent also may be considered, my lord. After hearing the, after argument on the same day,
to the conduct.
my lord, after hearing the application on IA number 1, on the same day intentionally they have co-opted the third respondent. That is deliberately they are doing
You
from
can draw the attention. You can draw the attention of KAT to the conduct of the respondents while addressing your arguments on merits. But only on that basis, this petition cannot be allowed. No.
No, actually, as on today, he has been continued, my lord, as the director, and even the election also declared. Furthermore, the election also declared only for one or.
The petitioner being the petitioner who was the one of the directors of respondent number 1 society has approached this court seeking issuance of writ in the nature of certiorari. Request the order dated 27/10/2025 passed by Karnataka Appellate Tribunal hearing after KAT. Scheduled on IA number 3, produced as per Annexure F. Heard so and so. Review the materials and record. The admitted facts of the case are that the petitioner, who was the director of respondent number 1, tendered his resignation on 27/6/2023. However, he was called upon to attend the meeting on 23/8/2022. On the said date, on 23/8/2022, the resignation tendered by the petitioner was accepted. Admittedly, the petitioner had not withdrawn his resignation till 23/8/2022. However, the petitioner has raised the dispute under Section 70. The said dispute was rejected, upon which the appeal was preferred before KAT. It is stated that on 21/8/2025, 21/2/2025, the KAT has passed an order staying the operation and further proceedings. Really, the ordered page number?
Page number 47, my lord. Forty-seven.
Yes. Staying the operation and further action on the decision made on issue number 12 on 23/8/2022 by respondent number 1 till next date of hearing. Next, it is the contention of the contesting respondent number 1 that on 19/2/2025 itself, respondent number 3 was co-opted.
But I seek your, and my permitted go on. My colleague will be here.
Co-opted in the place of respondent number 1, in the place of the petitioner whose resignation was accepted. Under such circumstances, respondent number 3 continued to hold the office of a director. Next, the petitioner filed PA number 3, KAT. Seeking to stay the operation and implementation of the resolution number 3 dated 19/2/2025 passed by respondent number 1 society. The said application was came to be dismissed with a order dated 27th October 2025 produced after an exam. The same is impugned by the petitioner in this petition. The admitted batch stated above is closed. That respondent number 3 was co-opted by respondent number 1 as one of the directors. As per the resolution dated 19/2/2025. It is thereafter the interim order as per annexure C was came to be passed by KAT, staying the operation and further action on the decision made in issue number 12 on 23/8/2022 by respondent number 1. By that time, the respondent number 3 was already co-opted, as there was no interim order of stay. Under such circumstances, I do not find any justification for the petitioner to challenge the order impugned. Annexure F. The appeal is still pending consideration before KAT. The petitioner is at liberty to raise all his contentions which shall be considered on which. Since I do not find any merits in the present petition, the same is dismissed. Yes, petition dismissed.
Period number 6, Mantrayadi, Harish HV.
That this If a lordship permits, I have 2 points and to assist the court. Can I add?
What is the point?
My lord, only point, my lord, I have prepared a synopsis to assist the court, number one.
Both of you have addressed the arguments.
My lord, in the will, only 2 points, my lord, which I had left out. In the will, the word panchayatadars are used, lordships. I have even the appellate court judgment, first appellate court judgment also, my lord, construction of the document, it doesn't disclose it as a will.
Yes, ಅದೆಲ್ಲ ಹೇಳಿದ್ರು.
And panchayatadar ಅನ್ನೋ words use ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
Yes.
My lord. Secondly, my lord, lastly, my lord,
Will exhibit?
Exhibit P1, my lord. Panchayatadars ಅಂತ use ಮಾಡಿದ್ದಾರೆ. And the appellate court, my lord, rightly have concluded that, my lord, it is not a will. The wordings are that, my lord, it is given on the same day, the portion is given on the same day. My lord, that is done. My lord, secondly, my lord, much was argued on the date, my lord, date of the will. My lord, that also I have said. It is 25/1/1956 in the plain government's lordships. Whereas, my lord, the document and all other exhibit P3 also discloses that, my lord, it is 1950.
Yes.
And my lord, lastly, my lord, this much was argued on the annexure to the will, my lord. Or more jana, my lord, that is not even marked, my lord. Because what is marked is
Pleading, no evidence.
No pleading, no evidence. Exhibit P1 matra mark agirodu as a will. I don't know, my lord, how did that second document come into existence? And lastly, my lord, the substantial question of law is only that, my lord, section 90, whether it is applicable or not. Kindly look at that, lord. The registration, the 30 years old document.
Yes.
Will it be applied to the will or not? Lord,
Will
two
is
decisions have given, my lord, that it is not applicable to the will.
Yes. It is expressly excluded.
Expressly excluded.
Yes. Stephen. Yes. Appeal is dismissed.
Serial number
Is
7.
this for- Yes.
Ajay Kumar Patil, Ketan Kumar, Rakshit Kumar.
In this minute, I appear for the respondents, 8th respondent council. It may kindly be taken up on Thursday or Friday in the afternoon. Some difficulty today. Thursday or Friday.
Friday ಆಗಲ್ಲ ಸರ್.
ಅಲ್ಲ ಒಂದು ಯಾವ್ದಾದ್ರು ಮಧ್ಯ.
Order sheet. Yes, sir.
ನಾವು ನೋಡಿದ್ರೆ ಈಗಲೂ ಬರ್ತಾ ಇದೆ ಪರ್ಮನೆಂಟ್ ಆರ್ಡರ್. ಹೀಗಾಗಿ ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಗಿದೆ. ಬ್ಯಾಂಕ್ ಪರವಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕನ್ಕ್ಲೂಡ್ ಆಗಿದೆ.
ಹೌದಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಪೂರ್ತಿ ಆಗೋಗಿದೆ. ಅವರು ಇದು 3ನೇ ಸತ್ತಿನೋ 4ನೇ ಸತ್ತಿನೋ ಟೈಮ್ ತಗೋತಾ ಇದ್ದಾರೆ. Let there be a peremptory order against them and let it be called tomorrow. Then it's senior. I don't want to oppose adjournment when then it's senior consideration.
ಈ ಕಾಮೆಂಟ್ಸ್ ಏನಿದೆ, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಇಯರ್ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್.
ಅದಿದೆ ಅದು. Yes.
ಆ ಇಯರ್ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ನೋಡಿದ್ರೆ ಪೆಟಿಷನರು ಎಷ್ಟು ವರ್ಷದ ಮೇಲೆ ಕೇಸ್ ನಡೆಸಿದ್ದಾರೆ ಅಂತ. It was very ungracious of my learned friend to make that submission.
Sir, if we go through the order sheet, there is every justification for passing such order. Yes.
That's why I have argued. But now there should be a
all that I am saying is.
No, he has to address argument. Yes. He is seeking time, aste.
Let it be called tomorrow. I don't want to oppose it.
Tomorrow agalla. I will. You are for which respondent?
8th respondent.
Senior advocate for respondent number 3.
That should not be.
Sir, parted ಆಗಿದೆ ಇದು. Parted ಆಗಿದೆ. Release ಮಾಡ್ಬೇಕಾ?
ಬೇಡ. ಅದಕ್ಕೋಸ್ಕರ ನಾವು
if any of you are interested, I will release it from part.
I don't know why my learned friend is.
I want to say my lord will proceed to judgment.
I have to hear them, sir. How can it be?
ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ನಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ
10 ವರ್ಷ ವೇಟ್ ಮಾಡಿದೀವಿ ನಿಮಗೋಸ್ಕರ.
ಹಾಗೆ ನಾಳೆ
I appear for respondent number 5 liquidated. Submission.
Learned senior advocate for respondent number 5 and 8. Pray for time.
ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ. ಏನು ತೊಂದರೆ
This time. ಯಾವಾಗ ನೋಡಿ. Huh? Yes. 15th, Monday.
Please.
15th, but 14th.
14th, Allah, 14th.
16th Sunday.
16th. 16th.
Please.
16th. Yes.
My lord is treating it as partner.
Already part.
Oh, sir. Already further argument ಅಂತ ಇದೆ.
There is no order to that effect. We have gone through the order sheet. There is
Sir,
no order to that effect.
as per the cause list, it is for further arguments.
Before further, but
That
there is no
means
order sheet that it has been heard in past. That is all.
ಆಗಿದೆ. Heard counsel for the petitioner andre, that means it is further argument. ಏನಾಯ್ತು? Yes, order sheet also says further arguments.
Further ಅಂತಿದೆ. I am not disputing.
Please go through the order sheet and make your submission, sir.
I apologize.
Next.
Serial number 8, Roshan.
Yes, I appear for respondents. I seek for a short accommodation.
To see whether there's any order passed by them before initiation of winding up proceedings.
Seek for a week's accommodation. The DSG has to appear. Kindly.
Alla,
a week's
ASG
accommodation.
appear agli first court order comply
We
madli.
will comply with it. We will comply with it.
Whether a separate order of winding up passed by the central registrar.
Will make my submission.
ಏನಾಯ್ತು? ನಿಮ್ಮ submission ಏನು?
Week's accommodation.
Alla, weeks, I have no problem. The question fact remains whether
I
there
will
is.
place it, Millard. I will place it.
Correct, that is there, he has to.
ಅಲ್ಲ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು then we can ಬರುತ್ತಾ?
ಅದನ್ನ ಹೇಳೋದಕ್ಕೆ he is seeking time. Yes.
Sure.
Then counsel for respondent place the time. ನೀವು CGC ನಾ? ಅಲ್ಲ, ಹೌದಾ? Yes, then it's CGC place for time. ಯಾವಾಗ ನೋಡಿ further argument, next Monday. Yes.
Serial number 9, Aditya Ramesh Pandey, Pradeep Kumar, Sridhar.
Interplay between the Karnataka Apartment Ownership Act.
Correct, RERA and.
My lord, I am the impleading applicant, and because I am individually affected by this petition, so I may be permitted to. I have already filed my application to the party.
You are?
My lord, I am for the respondent 3.
ಅಲ್ಲ, impleading ಯಾರು? Impleading
Yeah,
application
14%.
filed by-
14%.
ಯಾರಿಗೆ?
I am the allotee of the apartment promoted by the petitioner, and I am affected. I am a retired central government level grade 15.
You are the owner of an apartment.
Yes, allotee, not a donor. For the last 2 years, my apartment has not been registered because I have been asked to register at 1/3 the price. And
The
the,
filed application, IA number?
Yes.
outstanding.
today it is filed, madam.
Have you filed the application?
Yes, I have filed the application today.
Then
Online, I
filed
filed
it.
it online and submitted the hard copy today.
Yes, copy served.
I have not received the.
You have to serve the
It is
copy on the
served,
other side, sir.
I have served through mail. So, all the.
I have to check my mail.
My lord, my rights are significantly affected because I'm been asked to, for the last 2 years, to register the property at 1/3 the price. And if you see the records, all the 395 apartment owners have registered their sale deed at 1/3 the price. I may be permitted.
What is your name?
Prabhulla Chandran.
Some office objections are raised on form number A and
That
B.
we have complied, my lord.
When you complied it?
Yeah, we'll comply. We have already submitted.
You have not yet complied.
We have submitted the IA, the copy.
No, office has raised some objections.
No,
You
that
have to
I
comply
will
that.
comply today.
Unless you do that, the application will not be put up for consideration. First comply with that. You serve the copy on the other
In the
side.
course of the day, I'll comply, my lord.
It matter may be heard, my lord, because it was heard on last occasion, and they created the hue and cry that it should be heard and all those things, and it is heard at length. And now this application is only to derail the entire proceedings.
No, it's not.
And if he is an impleading applicant, he is an individual person.
applicant Shri Prabhulla Chandran V is present physically before the court and submits that he has filed an application seeking his impleadment. The office note in the cause list shows that the office has raised objections regarding Form A and B filed by the applicant. Applicant prays for time to comply with the office objections and to serve the copy of the application on the learned counsel for the petitioner. Yes, you do it. In the meantime, I will hear the matter. Yes. You comply. What is the objections? You have to comply with that and serve the copy on the other side.
Obliged, my lord.
Your Lordship, last date.
Hmm?
The last date, Your Lordship, I had partly addressed the arguments and Your Lordship had directed
You are for respondent number
3, my Lord.
3.
Yes. I am the cooperative society, my Lord. Statement.
You registered the cooperative society.
I am the registered cooperative society, my Lord. So,
So it is your contention that unless the association is registered, it will be only a voluntary association of owners. So as required under RERA, you got registered the association under Cooperative Societies Act. That is your contention. Yes.
so the case of the plaintiff is that
ಅದು ಗೊತ್ತಾಯ್ತು ನಮಗೆ. What is your
they
contention ಅಂತ?
want my registration to be quashed.
Sir, I understood his
Yes,
contention.
yes,
I am
yes.
asking about your defense.
Yes, my Lord. My defense is that, as this court in the Honorable Supreme Court, my Lord, has categorically observed in
Sir, Supreme Court ಗೆ ಹೋಗ್ಬೇಡಿ. Simply I am asking you, what is your defense?
my Lord, my defense is Karnataka Apartment Ownership Act cannot be made applicable to the RERA projects after the enactment of RERA and as held by the Supreme Court. This Karnataka Apartment Ownership Act cannot be made enforced. It cannot be enforced because it will amount to repugnancy, and enforcement of Karnataka Apartment Ownership Act will render enforcement of RERA provisions impossible.
Yes.
Your Lordship, the Honorable Supreme Court, my Lord, in a petition filed by the same petitioner, a petition defended by the petitioners, my Lord. Your Lordship, it's a very small judgment, which has dealt with explaining what is Karnataka apartment ownership in a nutshell. Your Lordship, I'll not take much time, but I want to take the entire facts has to be in page 2 of that, my Lord. This civil appeal.
Same decision was cited on the.
Yeah, it is there, my Lord. I am giving the Supreme Court SEC copy so that it will be easy, Your Lordship. It is there already.
Already you have cited that.
Yeah, my Lord, that was a printout of the Supreme Court judgment, my Lord. I just produced the SEC copy so that reference of para will be easy, my Lord.
You have to say that once you
I'm sorry.
You have cited SCR. Now you are saying SEC.
No, I just, for the convenience, I'm just passing over the.
Creating confusion. Same decision.
Same decision, my Lord. I'll go with the fact.
ಅದನ್ನು ಹೇಳ್ಬೇಕಲ್ವಾ ನೀವು?
Because the para reference is easier, my Lord. May I please, my Lord?
1 minute. You are referring to which paragraph?
From the beginning, my lord, the judgment of the court my lord, in page 2, the second page, my lord. This civil appeal under section 223 of the Consumer Protection, your lordship gets it.
Yes.
This civil appeal under section 23 of the Consumer Protection Act 1986 is filed by the complainant aggrieved by the order dated 13/5/2015 passed by the National Consumer Dispute Redressal Commission NCDRC, New Delhi, in Shobha Hibiscus Condominium versus Shobha Developers Limited. The petitioner herein and the respondent in the petition are the same.
Yes.
Rejecting the complaint filed by the appellant on the ground that appellant condominium has no locus standi to file the complaint, since neither it is a consumer nor it is a recognized consumer association with the meaning of section 12 of the Act. The appellant complainant is a statutory body under the provisions of Karnataka.
By this Supreme Court.
My lord,
What was held by this?
the court held that, my lord, the Karnataka Apartment Ownership Act does not make a registered association. That makes it such an association cannot approach the consumer forum.
Yes.
And identically, it cannot, my lord.
The relevant paragraph.
Para 9, my lord, in the SCC, if your lordship can. The operative portion is last one. My lord, I'll read only three paragraphs, my lord. 9, 11, and 13, and the final paragraphs. In the SCC copy, my lord. The Karnataka Apartment Ownership Act 1972 is an act of.
Yes, proceed.
The Karnataka Apartment Ownership Act 1972 is an act of the state which is enacted with a view to provide for the ownership of an individual apartment in a building and to make such apartment heritable and transfer property and the matters connected therewith. The appellant body has come into existence pursuant to a declaration made by the opposite party in terms of 1972 Act. Section 3J of the 1972 Act defines declaration as under. I'm skipping that, my lord. Then para 11, my lord.
Yes.
On a conjoint reading of the various relevant provisions of 1972 and the bylaws of the condominium referred to above, we are of the view that the appellant body has come into existence as per the mandatory provisions under section 1972, mandatory provisions of the Act. It is clear from the objects of the Act that it is an act to provide ownership of an individual apartment in a building and to make such apartment heritable, transferable in view of the mandatory provisions of 1972 Act. The appellant cannot be said to be voluntary registered association for the purpose of filing a complaint before the competent authority under the provisions of the Act.
What does it mean?
The explanation of section 12 of the Act makes it clear that the recognized consumer association is referred to under section 12B of 12(1)B of the Act means a voluntary consumer association registered under the Companies Act 1956 or any other law for the time being in force. My lord, the court emphasized that it should be a registered body. It should be a body corporate, voluntarily registered. Only then it can represent. Para 13, my lord.
Yes.
In essence, a voluntary consumer association will be a body formed by a group of persons coming together or their own will and of their own will and without any pressure or influence from anyone and without being mandated by any other provision of law. The appellant association, which consists of members of the flat owners in a building which has come into existence pursuant to the declaration which is required to be made compulsorily under the provisions of 1972 Act, cannot be said to be a voluntary association to maintain a complaint under the provisions of the Act. The learned counsel appearing for the respondents also relied on the very same judgment of Malavigam Trust Heights flats affected by us. In aforesaid decision, the full bench of National Commission has taken a view that even a residents' welfare association, if registered under any statute, will qualify as a consumer association under the provision of section 12 of the Act, provided it qualifies as a voluntary association. My lord, under the same petitioners defended a complaint for deficiency against them in the Consumer Act and made it clear that by a Supreme Court's, the judgment, a law is made clear that an association under 1972 cannot approach for any redressal before the Consumer Act.
There is no
And
provi-
identically,
There is no provision in KOA Act 1972
no, my
to
lord.
register the association.
My lord, it doesn't say. It only speaks about filing the deed of declaration register. No, my lord, section 31 of the RERA.
That is filing of deed of declaration under which provision?
One.
Could you? Karnataka Apartment Owners Association.
Not yet. 3J, section 3J of 1972.
No, that is the definition of the word declaration.
Yes, my lord.
Ah.
The
Which
contents, my
provision
lord, is in
provides?
section 13.
Section?
13, my lord. The contents of declaration is 11.
After 13 is.
So filing is under section 13, declaration deed of apartments and copies of the floor plans to be registered.
Section 11.
13 of Karnataka Apartment. Yes.
To be registered.
Yes. So a deed of declaration
With whom it is to be registered?
before the sub-registrar office. My lord, these provisions, it will contradict to the RERA. Because,
which is the section which is repugnant?
my lord, repugnancy is from the very beginning itself, my lord. Because the first thing is, what constitutes the repugnancy, my lord, the Honorable Supreme Court has.
Is there any provision under RERA to direct the registration of the association?
Yes, my lord. Only a registered association can approach the RERA, my lord. Section 31. Filing of the complaints with the authority or the adjudicating officer, my lord. Any aggrieved person may file a complaint with the authority or adjudicating officer, as the case may be, for any violation or contravention of the provisions of this act or rules and regulations made thereunder against any promoter, allottee or real estate agent, as the case may be.
There is no provision which enables this association to register.
My lord.
There is no specific provision under RERA for the association to be registered.
No, it says, my lord, 11(4)(e), which says it is the builder should enable the formation of an association or society or cooperative society, as the case may be, of the allottees or a federation of the same under the laws applicable. It is again only they should enable, and it is not their prerogative, as it was argued by the petitioner, my lord. So, my lord, in section 31 itself, my lord.
No, 1 minute, sir. Where there is reference to cooperative society registrar in section 11.
11(4)(e) is one.
11(4)(e).
4E.
Enable formation of association or society or cooperative society, as the case may be.
of the allottees or a federation of the same.
When registration of the society will arise, when the registration of cooperative society will arise.
My lord, that is a requirement because an unregistered body cannot represent. Section 31 explanation for. Where is that? Within. And
So
this,
under some circumstances, it is to be registered as the association or society or cooperative society.
whatever, my lord, that is the choice of the people according to the local laws and prevailing, and where the RERA can be enforced. Depending on that, it can be done. For that, my lord, section 31, it's clear. It says that for the purpose of this section, person shall include an association of allottees or voluntary consumer association registered under any law for the time being in force. So, my lord, a complaint can be made by only a registered association. So, my lord, any of these provisions.
Registration can be as an association or society or cooperative society.
Whatever, my lord.
Yes.
Any of that is a choice. And even a Companies Act. Under a company, it can be a company also. And in the same way, even under the appeal, my lord. Section 43, right? I cannot even appeal if I'm not registered.
So such registration either as association, society or cooperative society or as a company.
A company.
Except company, others are under the local acts, enactments.
Yes, my lord.
As the case may be in a word act bantu.
My lord, there is, if at all local law provides separately, where it, my lord, whenever it is a state law, in the concurrent list, if the state want to, state cannot dilute, but it can intensify that. So if they are bringing any much more stringent enactment which provides for that, then that can be adopted. But in this case, unfortunately, it is not there.
So your first submission that KOA cannot be made applicable or cannot be implemented in view of the implementation of RERA cannot be accepted.
It can be accepted because, my lord, without a registered body.
Only to that extent which is repugnant to RERA.
Yes.
Local law cannot be looked into.
So this is 89 of RERA Act also, my lord.
Totally
Anything which is
cannot be thrown away.
My lord, 1972 throwing away is not my case. They are saying I should be thrown away.
No.
I am only defending the case.
First, your submission is that KOA cannot be made applicable or it cannot be implemented.
Implemented unless
in view of RERA.
RERA. That is what I'll demonstrate, my lord. Now, my lord, when the RERA was enacted, the same case, my lord, an unregistered association neither can file a complaint nor appeal it. Now, my lord.
Sir, that is very settled now.
Yes, ma'am.
Where is the compulsion to register the association only as a cooperative society?
Yeah, yes, ma'am. Now, the another section of RERA.
Here.
Now, another, the 11.4F, my lord. The next provision.
Yes.
Execute a registered conveyance deed of the apartment, plot, or it is a duty of the promoter, my lord. Execute a registered conveyance deed of apartment, plot, or building, as the case may be, in favor of the allottee, along with the undivided proportionate title in the common areas to the association of allottees or competent authority, as the case may be, as provided under section 17 of the Act. Now, my lord, the section 17, my lord.
All this, there is no dispute with regard to all these requirements.
Dispute is very clear, man. A 1972 association cannot be a party of conveyance, where section 17 is a mandatory compliances, and I lordship last date I had taken your lordship to the certificate issued to the promoter while registering under the RERA with.
As far as I understood what the arguments addressed by the counsel for the petitioner as well as by you, the moot question is, according to him, it need not be registered under Cooperative Societies Act. According to you, it is to be registered under Cooperative Societies.
My lord, it is my humble submission is either it should be a cooperative society or any body corporate which can
Society also, association.
any body which is registered and which is a body corporate.
Need not be specifically under Cooperative Society.
It need not be, my lord. It is a choice.
So I am asking you whether RERA, when RERA does not say that it is to be registered under Cooperative Societies Act or any such local laws.
No, it RERA says that a project is completed when it is mandatory for the promoter to convey the common areas in favor of that.
Yes.
So I am saying that 1972 Act does not qualify an association to comply with these provisions. And 1972 has other repugnancies where it allows other than the allottees to be the members of the association, which is again repugnant. That is, the Supreme Court has held that any provision that is repugnant and the Act itself that cannot be enforced and it is void.
Regarding registration, there is no repugnancy.
Registration is a mandatory thing.
Of course, there is no.
Yeah, when it is unregistered, it is not an association which can be recognized under RERA. That is my contention.
Regarding registration of the association.
Yes, ma'am.
There is no repugnancy between RERA and the local law.
It is, my lord, because the Karnataka Apartment Ownership Act does not provide for registration. That is the repugnance.
Section 13, just now you read it.
That is the deed of declaration registration. It is not the association being registered. The deed of declaration registration did not make it a. That is what the Supreme Court has held very clearly. So by registering a deed, that is, my lord, again, the state in its objection also has clarified that very clearly.
Yes.
By merely registering a deed of declaration before the sub-registrar office will not make the association a registered body corporate. And that has been upheld by the Supreme Court in hibiscus matter. And when there is no registered body, section 17 cannot be complied. And admittedly, that compliance under section 17 required has not been done by the petitioner here. And they are claiming that we are handed over, which is illegal. And I wanted to agitate this, and I filed complaints before the RERA. That is why they are before this court asking a quashing of this petition. Your lordship may kindly see the standing committee report when the RERA was enacted.
Yeah. Standing committee report.
Your lordship, page 56, the printed page, my lord, it is below. Before enactment, my lord, a standing committee was formed and they conducted a detailed study. A standing committee, thereafter a select committee of the Rajya Sabha members. A detailed discussion is about the clause 15.
Before enactment of RERA.
RERA. So, my lord, in that page 59, I'm sorry, 4.28, the point. It starts actually the clause 15 in the discussion is the clause 17 now when it was enacted. There, all the local laws, all the consequences, everything has been discussed. The lordship will start at that clause 15 at 4.16, your lordship, page 56 in the other page also. I'll read the entire thing. Clause 15 relates to the transfer of title. That is the same thing which we are referring in section 17, my lord. When it became the act, it became section 17, my lord. The clause 15 reads as under the original bill. The promoter shall take all necessary steps to execute a registered conveyance of deed in favor of the allotee along with the undivided proportionate title in the common areas, including the handing over of the possession of the plot, apartment or building, as the case may be, in the real estate project and other title documents pertaining thereto. After obtaining the completion certificate and handing over the physical possession of the allottees in terms of subsection 1, it shall be the responsibility of the promoter to hand over the necessary documents, plans, and including common areas to the association of allottees or the competent authority as the case may be as per the local laws. This was what was existing and this is the bill, my lord. What happened further? Let me see. Subclause 1 of this clause provides that the promoter shall take all necessary steps to execute a registered conveyance deed in favor of the allottees along with the undivided proportionate title in common areas, including handing over of the possession of the plot, apartment, or building as the case may be in a real estate project and the other title documents pertaining thereto. Subclause 2 of this clause provides that after obtaining the completion certificate and handing over physical possession of the allottees in terms of subsection, it shall be the responsibility of the promoter to hand over the necessary documents and plans, including common areas, to the association of allottees or the competent authority as the case may be as per the local laws. Again, till then in the discussion all it is about handing over, and that is what my learned friend for the petitioner was arguing. 4.18, my lord, suggestion has been received that under section 15(1) transfer of title, once the FSI, FAR, or I emphasize, my lord, once the FSI/FAR is of a given plot has been consumed, exhausted by the builder, the plot would be automatically deemed to have been conveyed to the existing flat owner society or the flat owner society on the plot, and all benefits from the date of deemed conveyance onwards would accrue to the flat owner society. That then it was considered as a deemed conveyance. Further, my lord, on this suggestion, the Ministry of Housing and Urban Poverty Alleviation opined as under these matters of development to be regulated by the state laws like Development Municipality Act, Apartment Ownership Act. This clause only makes a reference to the local laws towards timely transfer of title. A suggestion has been received that under clause 3 of the Real Estate Act, there should be a specific time frame of 2 months from for the registration of a conveyance deed. Registration of a conveyance deed from the date of handing over of possession of the to the allottees. On being inquired about the feasibility of the above suggestions, the Ministry of Housing and Urban Poverty Alleviation submitted as under clause 15 of the bill is in its current form does not define the time frame with the within which the conveyance deed needs to be registered by the promoter. However, the ministry is not averse to the idea of defining the time frame by executing the conveyance deed. However, this point will need to be legally examined. In context of clause 15(1), another suggestion has been received which reads as under the promoter shall, my lord, this is I emphasize on this, the promoter shall execute registered conveyance in favor of the allottees purchasers along with the undivided proportionate title in the common area and under the state law to the conveyance of the property is to be granted to the association of the first flat purchasers, which is normally a society registered under the Maharashtra Cooperative Society Act, but it could be a company incorporated under the Companies Act 1956 also, or any other incorporated identity. I emphasize, my lord. Therefore, a society owns the land along with the building, and flat purchasers have right to use, occupy, transfer the said flat. However, if a proposed conveyance is granted to the purchaser of his undivided share, my lord, I emphasize again. However, if a proposed conveyance is granted to a purchaser of his undivided share in that case, he becomes the owner of undivided property, and no decisions can be taken unless there is a unanimity and single person can stall everything, whereas presently a member is bound by the decision taken by the society. This aspect needs serious consideration. On the above suggestion, the Ministry of Housing and Urban Poverty Alleviation opined as under. Clause 15 provides for handing over of the apartment, etc. to the allottees. Consequently, a reference is in the registered conveyance deed is also made to the undivided interest common area, which is together owned by the allottee. The same is managed by the society association, which are regulated by state laws like Apartment Ownership Act. Thus, the provision is rightly provided. With regard to clause 15.1, representative of RBI during oral evidence on 6/12/2013 submitted as under. As regards clause 15.1, the interest of allottees, the bill understandably has effective provisions for execution of conveyance in favor of the allottees. It may, however, be noted that when cooperative housing societies are formed by allottees, the conveyance of the land building is required to be made to such cooperative society. As such, in addition to existing provisions of requiring conveyance to be made, my lord, I emphasize here, as such, in addition to the existing provisions of requiring conveyance to be made in favor of allottees, an additional provision for conveying to the cooperative society or any other body corporated constituted by the allottees may also be made wherever circumstance so warrant. In clause 15 of the real estate bill, there is no time limit mentioned during which the registration of conveyance deed should be executed. A suggestion was received stating as under. Ideally, it should be within 2 months from the date of handing over of possession to the allottees. On being inquired about the incorporation of suggestion in the proposed bill, the Ministry of Housing, Urban Planning, as HUPA has suggested as under. Transfer of title upon development is provided for under local laws, thus not provided for. Further, the Legislative Department of Ministry of Law and Justice opined as under to extension of period for benefit of the allottee may be considered. Now the final opinion, my lord. Under clause 15.1, the promoter should execute a registered conveyance deed in favor of the allottee along with the undivided proportionate title in the common areas, including the handing over of the portion of the plot, apartment or building.
Even according to RERA, the association must be registered.
Yes, ma'am.
Ashte.
Adana registration should be this cooperative movement. This one complete madbirtini. Sorry, just one more that. Let me finish it. It is a final thing. Alala, 1970 it is not an association that can be recognized at all, my lord. That is only with the mischief. Huh?
It is settled that a association must be registered. Registered as a association or as a society, cooperative society or a company.
Also.
That is the option given to the association.
Yes, my lord. The association has registered itself.
Correct.
It has registered as a cooperative society.
Says it cannot be registered as a cooperative society since it is only the residential apartments are there.
No, that is
not the commercial.
No, that bifurcation of commercial and residential does not.
Huh? You directly come to the argument that is addressed by the
address, my lord, that is a false because that is the same.
Your argument
I will bring
that line.
Your lordship hear that because my lord, it is my lord, there is.
I don't know.
My lord, it is very clear that the same contention was raised that there cannot be a cooperative society in a residential apartment. Correct. And that has been overruled by the judgment produced by them itself in Akhilesh Anand matter. It clears.
Adana, you should highlight.
That is what, my lord, I am highlighting, and here why the legislative intention says that it should be a cooperative movement. It is along with when they are saying that undivided interest, it is mandatory that there should be the common area, including the land, has to be registered in favor of the allottees association. And allottees association under 1972 is not a body corporate. It cannot represent as a party to a contract. A conveyance deed nalli avರಿಗೆ represent ಮಾಡಕ್ಕಾಗಲ್ಲ. So they are not eligible for that. That is why the Karnataka 1972 cannot approach RERA also. So thereby the builder is very safe that no complaints by any allottee collectively will be made before any consumer forum or the RERA, and here, my lord, the deed of declaration is registered subsequently, which is again repugnant because when the registration before.
Now, after registering as a cooperative society, have you adopted the bylaws? Is pursuant to the cooperative.
Yes, ma'am. I with the bylaws only I register as a cooperative society.
Adeli bylaw produce madide.
Bylaw is the petition itself they produced. It is amended later also.
Only one point.
My lord, first and foremost, my lord, the respondent number 5 is not a registered entity. They cannot sue.
Bylaw produce madidira.
Come in.
Bylaw. Annexure E.
Of the petition, my lord. Petition copy. Annexure E, my lord, page 64 of the petition. Swami, page 68 nalli, the common area means Section N RERA Act 2016. These objectives have been later amended. No?
This is not
Page 73, Swami.
1 minute. Yes.
This bifurcation, again, the Supreme Court has ordered in a residential apartment. My lord, in a residential apartment, in the matter of my lord, Suman Jindal versus Adarsh Developers,
Illi there.
I'm producing. Where the another state act, my lord, the Flats Act,
Yes.
Section 4 of the Karnataka Ownership Flats Act was discussed, my lord. Here, in that para 3, my lord, the dispute in present case relates to a residential apartment which the appellants booked with the respondent, who is a developer. The respondent has launched a construction project called so and so. My lord, even though it was a residential project, the COFA has been made applicable. So the contention that in any residential project, it is only the Apartment Ownership Act applies is been overruled by the Supreme Court.
Really, which paragraph?
My lord, the
What are
The entire ruling in this, my lord, was applying the Karnataka Flats Act.
No principle of law is highlighted.
It is mandatory.
The
Only on facts it is discussed.
my lord, para 18.
Decision is fact specific.
It is co-form mandatory.
It has made that Flats Act mandatory in that, my lord.
No, any principle of law is laid down or highlighted or reiterated. No, only
The law,
facts are
law is highlighted where, my lord, any act, local act, which comes in the way of enforcement of RERA cannot be enforced, is the Supreme Court's judgment in People's Forum for Collective versus the West Bengal government.
Next.
The lordship. So, my lord, now the same contentions was raised that a cooperative society cannot be formed in a residential apartment, and the judgment produced by the learned friend in Akhilesh Anand matter, my lord. Your lordship, there, the state's objections also is very important to be considered. What the state has to state objections.
14 point. 14.
In WP number 27341, my lord.
WP number?
27341, my lord. That the party is Akhilesh Anand versus Commune Apartments.
They ಕೊಟ್ಟಿದ್ದಾರಾ ಅವ್ರು?
They have submitted it.
ಸೆಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
During 29.8, where it is concluded, 29.8.
Yeah, come there. May I please, man?
Yes.
The state's objections, man. They've taken a consistent stand here, also in a PIL, where 1972 is the registration of deed of declaration has been discussed. Page 123, my lord, para 14.
ಆಯ್ತು ಏನು what was held by the coordinator?
The state says very clearly, my lord, mere filing of a deed of declaration, a cooperative society is the right thing.
What is the finding recorded by the court?
My lord, binding is, my lord, 29.8, my lord. What is the page?
29 or 28?
29.8, my lord, the court's observation.
29.8.
In view of, there also, my lord, the same thing was done. They wanted to quash the registration of the cooperative society, which had taken over the project. The court made a finding contrary to the views taken by even the division bench, observing that when the division bench considered the matter, it had not considered the RERA. It has been categorically observed here. And in RERA projects, it is a cooperative society which is required to be there. In view of the above discussion, it is clear that a cooperative society could both agitate the rights of the allottees vis-a-vis the promoter developer, as also carry out the maintenance activity of the apartment, including that of the common amenities and common areas. In this situation, I am of the considered opinion that the respondent number 8 cooperative society, which has been registered in the present case, can carry out the maintenance activity in respect of in the present case, carry out the maintenance activity in respect of the apartment complex. And more importantly, the grievances of the petitioner is completely unwarranted. Their agitation that the cooperative society cannot be made applicable in a residential apartment and it is against the division bench order was been negated. The court found that a cooperative society is the right forum. My lord, your lordship, it is from para 29. Man. It clarifies the entire thing. Man. Page 200, my lord.
Yes.
In view of my answers to the various points above, at the cost of repetition, it is being clear that it is an association of 1972 that can carry out the maintenance activities of the apartment clause. Such an association could be formed only by owners as indicated supra. In the present case, such an association under KU 1972 not being capable of being formed, such an association could have to be formed only after conveyance of all the apartments in favor of the respective allottees. The owners coming together to form such an association under KU 1972. Here, all conveyance is not done. Admittedly, it is only partly it has been done. Out of 395 apartments, only 233 has been done, and the DOD was registered much before to that. The association, what they claim has been made when even the no sale deeds was being done. The petitioner number 59 society also respond number 7 association being a society registered under Karnataka Societies Registration of 1960 would not be entitled to carry out any maintenance activity in view of decisions of this court in so and so matter, my lord, VDB Seldon, and where the 1960 association cannot indulge in maintenance activity. Thus, they would have to be restrained from carrying out any such maintenance activities. The cooperative society now having been formed, the builders, developers would have to execute necessary deed of conveyance. This is the most important matter.
Yes.
The cooperative society now having been formed, the builders, developers would have to execute necessary deed of conveyance in respect of the common areas and amenities in favor of the cooperative society. Within a time-bound manner, that is, within a period of 120 days from the date of receipt of this order. My lord, conveyance under section 17 is a mandatory requirement under RERA. A 1972 Act cannot be a party to that. That is why there is a categorical observation by this court in the coordinate bench where it is a RERA project for compliance of section 17. There should be a body corporate, and when there is a registered body, they are competent to be a party to that. Respond number 8, cooperative society having been formed by the allottees to agitate the rights of the allottees, identically the same here, madam, of the allottees against the promoters on account of non-completion of the apartment complex, improper works being carried out, etc. The cooperative society would be well within the rights to agitate those issues before the appropriate forum, since the aims and objectives of cooperative society would include such agitation of rights of the cooperative society representing all its members, it being the association of allottees under RERA 2016. The the Cooperative Societies Act 1959 enables a cooperative society to carry out maintenance activities of the apartment complex, including those of the common areas and common amenities. It is only the Karnataka Societies Registration Act 1960 which does not provide for such an object. Though this court in Starnest Apartment Owners Cooperative Society has held that for the purpose of cooperative society under COFA 1972, a commercial unit would have to be part of the development. I am of the considered opinion that the division bench of this court, while considering such restriction, was only considering Karnataka, that Flats Act, COFA 1972, and not RERA 2016. The enablement of a registration of cooperative society for carrying out the maintenance activity and agitation of rights of the allottees would have to be considered with reference to RERA 2016 and not COFA 1972, since most of the rights which would be agitated under COFA 1972 would have to be agitated by the allottees now under RERA and not under COFA 1972. My lord, because of RERA, COFA is no more applicable. RERA has come into this, and RERA, where it cannot be enforced by a state legislation, that will be repugnant. Several of the provisions of RERA 2016, this more important, my lord. Several of the provisions of RERA 2016 containing no non-obstinate provisions, RERA 2016 would override COFA 1972. Apart from this, RERA 2016 being a central enactment that occupies the field relating to the dispute between allottees and developer promoters, would override COFA 1972, a state enactment in order to maintain uniformity across the country. Taking into account these aspects and factors, I am of the considered opinion that the decision of division bench of this court in Starnest Apartment Owners Cooperative Society Limited, holding that the cooperative can only be registered in respect of COFA 1972 if there is a commercial unit, would no longer be applicable after RERA 2016 has come into force. More so, since RERA 2016 was not considered in Starnest Apartment Owners Cooperative Society Limited. This would also have to be taken into consideration with reference to the provisions to clause E of subsection 1 of section 14, which requires that such an association is required to be formed within a period of 3 months of majority of allottees having booked that their plot or apartment. Thus, the association of allottees in terms of clause E of subsection 1 of section 14 could be, this is important, my lord, 14(1)(e) could be an association or a society or cooperative society. But if such an association were required to be carry out the maintenance activity also, then it could only be a cooperative society under the Karnataka Cooperative Societies Act 1959. And such a cooperative society is required to be formed within a period of 3 months from the majority of allottees having booked their plots or apartments. Here, the builder deliberately do not initiate that. Where when they initiated that is a cooperative society which was formed. In the present,
Only cooperative society. Only cooperative.
Let us clarify it in that order, my lord.
Yes.
Only the cooperative society. When it is under the and here the section 17 is not being compared. Until the section 17 is compared, it cannot be told to solve this. Provisions of recovery in my statement of petition pointed out each and every requirement, starting from the very first clause itself. The field is covered.
Yes.
And also, I am basing on record, my lord, the Supreme Court judgment on this. Any requirement and it is non-obstinate clauses 89 cannot be enforced. That stands void and it is confirmed.
ಯಾವುದು decision?
My lord, it is the judgment of the Honorable Supreme Court of 2021, decided on May 4th, 2021.
Why you are relying on this?
My lord, first is, my lord, take repugnancy first. No, repugnancy first. No, it is. Your lordship, 722 page number. May I please, ma'am? My lord, page 722, 51.6, ma'am. Repugnancy may be direct in the sense that there is inconsistency in the actual terms of the competing statutes and there is therefore a direct conflict between two or more provisions of the competing statute. In this sense, the inconsistency must be clear and direct and be of such nature as to bring the two acts or parts thereof into direct collision with each other, reaching a situation where it is impossible to obey the one without disobeying the other. This happens when two enactments produce different legal results when applied to the same facts. Though there may be no direct conflict, para 51.6, 51.7. Forum for People's Collective versus State of Law. Give one second. There are multiple copies. 2021-8 SEC 599.
Their reliance was placed on another decision rendered by the Supreme Court.
Your Lordship. Thanks.
Reliance was placed on another decision rendered by the Supreme Court.
My lord, those are regarding the repugnancy.
Yes.
Where the repugnancy, there are other statutes like.
Not be any dispute with regard to that. It is a very settled position of law. Who
Yes,
is disputing that?
My lord, that is why I'm saying RERA, and enforcement of RERA, the 1972 Act will come in the way, but from the very definitions itself, my lord, in the definition of COFA, only the owners can form an association. I mean, under the Karnataka 1972 Karnataka Apartment Ownership Act. But there is a requirement under RERA to form an association of the allottees. That means any person who has even booked the apartment will be eligible to become a allottee. He is an allottee, and that association should be formed when within 2 months from the date of booking of more than 50% of the apartments. So this enables the RERA's preventive provisions to be enforced.
Even the allottees can be the members, not only the owners.
No, the definition, my lord. The RERA definition. Allottees, the definition. 2D, my lord. And that discussion in the standing committee is also very detailed, my lord.
Select committee.
Standing committees.
Select
committee.
That is the definition of the word allottee.
2D, my lord.
Yes, definition of the word allottee.
Yes, my lord. And the association of allottee is defined under the rule, my lord. Rule 2B.
B.
2B, my lord, association of allottees. So, my lord, the allottee is a person who has even booked the apartment and till the owner. So, under the 1972.
No, that is refers to association of allottees.
Yes, only that is why it should be the association of allottees everywhere for RERA, my lord. It is not the association of owners. RERA do not refer to association of owners at all. And if it is the association of owners, that association cannot be formed under 11(4)(e), my lord. RERA requires formation of an association under section 11(4)(e) when more than 50% of the allottees have booked their apartment.
Yes.
So, an allottees association, an owners association cannot be at that juncture be formed. And section 8, my lord, in the event of the project lapse, the allottees have a right to take over the project. So again, 1972 will come in the way, my lord. Unless there is an all the allottees become an owner, they cannot exercise this right, and it did amount to an repugnancy, my lord. And under section, my lord, in section 8, my lord, in Karnataka Apartment Ownership Act. There, my lord, under the deed of declaration, The promoter can define the common area, which is against the RERA. RERA, my lord, whatever is the FSI FAR, the common area is defined. After that, it cannot be altered by without 3/4 majority of the allottees. So here, after the sale agreement has been entered with me, the builder goes on to sell the common area to private parties in the name of designated private gardens and all, my lord, which is the declaration permits that he can define a separate common areas where private parties will own the property belonging to the common the property in common, my lord.
Yes.
Description of the common areas and facilities. Description of limited common areas and facilities, if any, stating to which the apartment their use is reversed. This through a declaration subsequently filed, which is not disclosed at the beginning, which is a mandatory requirement under RERA. Before entering into any booking of the apartments, there should be a total disclosure. Deed of declaration comes subsequent to that, wherein the deed where a limited common area is created. And again, any such discrepancies, 1972 association as in collective cannot approach either RERA or the consumer forum.
Yes.
And any dispute between the allottees and the promoter, no civil courts has jurisdiction.
Yes.
So the allottees in a real estate project under the RERA are left with no legal remedies at all. And incidentally, the petitioner herein, and where they have an order in their favor from the Honorable Supreme Court, which categorically clarified that 1972 association is not a voluntary consumer association, they cannot agitate before the consumer courts, and where because it is an unregistered association, the same law applies here. So they cannot approach the RERA also.
Now in your cooperative society, even the allottees are the members?
Yes.
Owners and allottees.
It is allottees, my lord, because they are not become a owner yet. There are people who are not become owners yet.
So now only the allottees have formed the cooperative society.
No, it is not, my lord. It is a mix of all, because allottees permit for everything. From booking till become the ownership, the allottees include. All owners are not allottees, my lord. All owners are allottees, but all allottees are not owners.
Yes. I am asking you whether the owners are also members in your cooperative
Owners
society?
also are members.
Allottees are also members?
Members. It is a mix of all. So all the allottees will qualify to be the owner, and then the section 17 has to be complied. Section 80 of RERA, my lord. Bar of 79, my lord. Bar of jurisdiction. No civil court shall have any jurisdiction to entertain any suit or proceeding in respect of any matter which the authority or adjudicating officer or appellate tribunal is empowered or by under this act to determine, and no injunction shall be granted. So, my lord, the allottees under the RERA will be left with no legal remedies at all. The allottees collective, which can agitate, my lord, the complaints under section 17, all the preventive provisions will go unenforceable. And this is particularly required, my lord. An association, if formed when 50% allottees have booked it, my lord, what the petitioner has done by mortgaging the property would not have happened, which under RERA it prohibits. Without the allottees' consent, they cannot mortgage the property. It is on the record, my lord, they had mortgaged the property without the consent of the allottees. These are the things the petitioner doesn't want me to agitate, and that is why he wants me to be quashed. That's all. That is my case.
So in view of your registration under cooperative society, you have to approach the registrar of cooperative
Before
society.
the registrar of cooperative.
Yes. What is the authority of the appellate tribunal?
Authority of the appellate tribunal of the RERA.
Yes, under RERA.
Authority, my lord, all appeal, section 43, my lord, of RERA. There also I cannot approach. My lord. The last explanation, for the purpose of this subsection, person shall include the association of allottees or a voluntary consumer association registered under any law for the time being in force. 1972 does not provide for registration. Shobha Hibiscus case very clarifies that it is not an association. Again, the order of this coordinate bench of this court also clarifies that it is not a registered association. Neither before the RERA authority, adjudicating officer, or the appellate authority, the association of allottees can be a party. And not only there, my lord, not even in the civil courts. An unregistered body cannot sue. And my learned friend for respondent number 5 is representing in the name of an association, which is not permissible, man. It should be in their personal names of the office bearers. It's the judgment. They have no locus standing as an association. They cannot sue in the name of an association. And most importantly, my learned friend was arguing about that there is a contractual obligation. My lord, if there is a contractual obligation and it's breach, then it is other forums to appropriate, not in the writ jurisdiction.
No, as a cooperative society,
My lord.
whether you can approach, the members can approach the appellate authority, appellate tribunal.
Yes, ma'am. Yes, ma'am. Only on an appeal of the orders of authority or
Appropriate authority.
yeah, from the adjudicating officer or the authority. Any orders, if I want to appeal, I can appeal before the appellate authority, and then thereafter it lies with this court, my lord. It comes before this court division. And my lord, there is again a misrepresentation claiming that that association is registered. So if there is a registration, they have to produce that such certificate. 1972 is not an association that is registered. That state has clarified that in the detailed objections they have filed in Akhilesh Anand matter. That has been extracted in the judgment itself by the coordinate bench.
Yes.
And also, my lord, regarding the discussions and finality of what the bill, after the bill, when it is concluded, each definition, why there was a difference, that has been in the select committee report, the discussion is there.
Next. Yes, you are for respondent number?
Respondent number
5.
The most important point for your lordship to consider, one of the arguments made by them said, we are not association of allotment, which has been clarified by the division bench, my lords. Please see the judgment of the division bench of this honorable court. In proposed Starnet's apartment owners versus state of Karnataka.
In respondent number 5 association, how many members are there?
We have KOA 100% ownership. In fact, their members are also members. They've signed Form B.
So all the owners are they or even members?
My lord, I am not a member. I am an allottee still, and I have not.
Owner. You are not the owner.
All owners have signed.
No, there is. My lord, I have filed another application also, my lord, wherein I say I have categorically brought to the notice of the court, my lord. There, this Form B has been obtained from people through unlawful means, my lord.
Whether respondent number 5 is a registered association?
Under KOA, our legal declaration is registered. Our bylaws are next to it. Every compliance under KOA has been undertaken by us. So we are a valid association so far as KOA is. Lordship, can you see the division bench judgment of this honorable? In proposed Starnet's apartment owners versus state of Karnataka by Chief Justice N.V. Acharya and Justice K.V. Arya. I understand copies of you.
Now, what do you say regarding the observation made by the coordinate bench?
No, I can't coordinate, but I will take it to the division bench because that is what is binding. That propriety cannot be missed based on the argument we were having. 16 of the division bench of this honorable court, which refers to RERA and calls the association under KOA an association of allotting other.
Para number?
Para 16. The narrow, I may not be interrupted, because I may interrupt my question. The narrow.
Which is the paragraph?
16. The narrow district.
1 minute, 1 minute.
The narrow dispute in the present case is whether association is to be formed under the Act of 72 or cooperative society is to be formed under KOF Act 1970, which is COCA. It is seen from the record that the sale deeds would indicate the entire project is for residential and no part of the project is used or intended to be used for commercial purpose.
Yes.
Exactly what happened. The parties in the sale deed are agreed to abide by the provisions of the KOA 1972 and form an association, which is again so far as our agreement to say that a sale deed is concerned, where the association of allottees under 1959 Act today have also signed these sale deeds in. The contention of learned counsel to the applicant that in view of the project being registered under the provisions of RERA, in compliance of section 11(4) subclause E, F, G of RERA, a cooperative society is to be formed is not acceptable, which is the argument by the making right in each section. Saying under 11(4), if your lordship rightly said that you can form association, cooperative society, that argument is not acceptable. The said provisions of RERA would mandate the failure to enable formation of association or society or cooperative society, as the case may be of the allottees. As the project under consideration consists only residential units, the said provision only mandate formation of association of the allottees under the applicable laws. The law applicable in the present case is KOA 1972. Please see the next paragraph. It is also important. The contention of learned counsel to the applicant that even if the project consists only of residential houses, flats, conversion of flats for commercial or use of such flats for commercial purposes is not prohibited. In such circumstances, provision of COFA would be attracted, and in compliance with section 10 of the Act, cooperative society is to be formed is far-fetched and is rejected. The learned single judge, after considering the relevant provisions under the statute of 72, COFA 72, and held that the property does not include commercial use. Conclusion of the learned single judge in the analysis and the way of business. So, my lords, the consideration of RERA, my learned friend is arguing on level 3-4 today is settled by the division bench. And this court is bound by that judgment right here.
Same deputy under review.
And there is no stay of the current order. The order is under operation. And therefore, when the division bench is already given its view, that's my first argument. My next argument is the learned counsel also relied on Akhilesh Anand heavily. One of the facts of Akhilesh Anand and the facts of our case has to be looked at by this honorable court. One was in Akhilesh Anand's case, there were 5 towers. 3 towers were completed and flats were sold. However, 2 towers were incomplete, and the direction given by the honorable single judge in that matter is so far as the 2 towers wherein sale is not yet happened. So the discussion was based that, and KOA was not formed by any of the towers in the judgment rights. The 3 complete towers registered association under the Karnataka Society Registration Act 1960, and the 2 incomplete towers registered themselves under the Karnataka Cooperative Societies Act 1959. Therefore, my lords, in so far as KOA, even though there are some observations made by the learned judge, as far as facts are concerned, KOA was not even under consideration rights. So therefore, my lords, even the direction given by the learned single judge and Akhilesh Anand was to say that you registered under section 17 because they were still allottees. When you're an allottee, no UDS has still been transferred to you. However, today, 100% of the flats, UDS has already been transferred under the sale deed. There is a question of creating another conveyance.
All the units are sold?
All units are sold.
No,
Maybe
some
one
are.
or two units have not been sold, but majority of the flats are sold. I didn't get that number because the association had that data. The lordship's going to get that data, those numbers. There is nothing to.
Last week of hearing I had provided.
Hmm?
Last week of hearing I had provided.
233 out of 295.
395 is the total apartment.
Huh?
395.
395 are sold.
So 395 are the total
Total.
units. Total units. And out of that, 321 have executed Form B under the Karnataka Apartment Ownership Act.
For which I have a series of.
No, let him have the objection. There, that is different forum. No.
No, 321 units are already sold.
No. 321 have submitted themselves for the Karnataka Apartment Ownership Act out of 395. That means it is registered and Form B has been executed.
My learned friend did not say how many is registered, my sale date. They themselves submitted that only 233 is registered. So they cannot submit Form B, my lord.
330 is filed in that many copies.
Form B cannot be filed by a non-owner.
My argument is, if this court, based on the argument made by the council, were to allow cooperative society to be formed, the problem that arises is this. Because today, my lords, all the owners have formed KOA 1972, number one. And all the UDS has already been transferred via sale deed, which is what is happening in Karnataka, my lords. In fact, in Akhilesh Anand, it's the first time that the court has directed, because they were association of authorities who are not owners. But this conundrum is something that the legislation has to see how the rules have to be made, because my lords are already aware. Today, the entire property management system, the registration process, there is no mechanism to even do conveyance of UDS of common areas in any manner. The registration system is not equipped. There are no rules framed by the government to enable this process under Section 17 of RERA. So therefore, what all the builders are doing today is they're giving you UDS along with your sale deed. In that sense, my lords, every single owner today owns some bit of land, and therefore association under KOA is valid, which is also what Akhilesh Anand judgment recognizes. It says RERA comes before ownership, but once you're an owner, that's when KOA comes. That distinction has also been made. My submission today is not that an association of allottees cannot be formed. However, I'm the right association so far as maintenance is concerned. I still get to maintain the association because I'm a registered body under KOA 1972, which so far every single judgment of Karnataka High Court is said, including Akhilesh Anand, that KOA can maintain association. I will point out, please look at paragraph 22.11 of Akhilesh Anand judgment.
Form B.
22.11.
Twenty-two point.
Internal page is 9. May I read out?
One additional. Yes.
Hence, I answer point number 3 by holding that there is no conflict between KOA 1972 and RERA 2016. In as much as RERA 2016 is applicable pre-ownership, KOA is applicable post-ownership, which is what our case is doing. Insofar as KOFA and RERA are concerned, there is conflict, but we are not concerned about it because we are KOA and RERA.
Oh, this project is already complete.
Please, project is complete, OC is received, EOD has been signed, Form Bs have been signed. I'll also see 22.1 well.
Yes.
On the completion of the building, RERA 2016 being applicable in respect of certain of the aspects. KOA 1972 being related to maintenance. RERA 2016 also providing warranty as regards the construction which has been done. There could be some overlap between RERA and KOA 1972, but however, at this stage, it could be the association under KOA which would aggregate its rights under RERA 2016. Since an association under KOA 1972 can, as read by the division bench of this honorable court in Seldon and enactments case, be the competent association to handle all aspects related to maintenance. And this is my concept. KOA permits me to maintain a apartment. I'm the custodian of the entire apartment complex. I'm allowed to collect maintenance. The statute is allowing me to collect maintenance. And even RERA, by the order of the division bench of this honorable court, recognizes KOA as an association of authorities. Therefore, if we look at the entire legal structure, my lords, I am the right association to maintain an apartment complex, which is what I'm doing today. I've taken over maintenance. Every single owner, including them, they are paying maintenance. Therefore, this is another aspect of this court of consider. The submission to my learned friend is basically that every association under KOA is redundant because RERA says only cooperative society associations can be formed. Whereas there are thousands of associations under KOA that have been formed today. And many projects are coming under RERA because RERA has been almost 10 years since its formation.
Yes.
Which means everybody today will be knocking on the doors of this honorable court to get them relief. If this honorable court doesn't recognize KOA 1972 as a right association for collection of maintenance, they are an association of allottees. They want to agitate against the developer. They have to let them go to RERA, agitate their issues under RERA. No objections to that. We are not objecting to their formation. We are only saying, so far as maintenance is concerned, we are the right association. We are recognized under the statute, under law. In fact, all the proceedings of this honorable court support our case. So therefore, for them to come and argue on repugnancy, unless the division bench has already stated the law rightly or wrongly, that has to be followed. Therefore, my humble submission is, so far as maintenance is concerned, I am the right association. And they cannot interject in that space because they're all owners. If they're an allottee, then your lordship would to consider that. But an allottee cannot even collect maintenance, and that is the observation made by application as well. Therefore, RERA is applicable only pre-ownership, KOA applies post-ownership.
Yes.
That is my opinion. I am available to clarify any points.
The filing of Form B. Your Lordship asked my learned friend to clarify how many sale deeds has happened. Sale deeds are 233 according to
323 it has been registered. Out of 395, 323 has been registered. Already it has been registered. That means approximately 85% has been
My
registered.
Lord, the registration of sale deed, prior to registration of sale deeds, there are Form B executed. Only an owner can execute a Form B, which amounts to, I have through an additional objections, my Lord, filed, my Lord, on.
Now, in this Akhilesh Anand, the bench has made it very clear, RERA is applicable for pre-ownership.
My question is,
KOA applicable to post-ownership.
Yes, ma'am. Here, the cooperative society was formed prior to all the owners being registered.
Now, there is already an association, R5 is.
Association was formed when there was a cooperative society application was made, my Lord, to overcome and to make sure that the cooperative society was formed to agitate our grievances before the RERA with regard to particularly one section.
The difficulties or the challenges that are faced by the allottees are entirely different from the difficulties of the owners.
My Lord, it is, see,
Combine all both.
my grievances as allottees, when I am being deprived of seeking a legal remedy.
As an allottees, you can form a cooperative society.
Yes, I have formed only that. Why should they ask for quashing the same? I have.
No, you said even the owners are the members of the cooperative.
Owners are, it is a collective of all, my Lord, because the owners, I am being asked to sign a dotted line sale deed.
Now,
There are two important things, my lord. One is the manner in which they obtained the Form B. There is forgery which has brought you to the notice of the court by filing an additional objections and brought the forgery on the face of it. There is a serious perjury committed by the petitioner, my lord, and the respondent number 5 by bringing in documents which are forged. That is a detailed thing, your lordship, in this matter has to be looked into. Another, my lord, they say that they are now conducting the maintenance. It is in the breach of the agreement, my lord. Sale agreement says they have collected per head 5 lakh rupees. And from the interest, the petitioner has to maintain the apartment. In shortfall, they will collect additional interest. And it has been in the sale agreement.
Whether the question, when all the owners are the members of respondent number 5 society.
No, my lord.
They can be the members of respondent number 3 as well.
My lord, here the issue is that is an unregistered association. They, through forgery, they have claimed that by form.
Forgery, you have to
Hesitate, yes.
This court will not give any finding.
Admittedly, my lord, when.
Writ petition, I am not going to give any finding. Right?
Yes, my lord.
You have to agitate your right.
Yeah, lordship.
In the meantime,
yes.
a owner, can he be the member of respondent number 5 as well as respondent number 3?
Yes, my lord.
Any number of societies.
I will clarify that, my lord, because admittedly, not all sale deeds are registered. Unless all sale deeds are
not registered.
Not all sale deeds are finished. 395 apartments, they admittedly it is
323 are registered.
323. The total number of apartments are 395.
Yes.
So there is no that unless and until the Act clearly provides, my lord, unless until all the owners submit to the Karnataka Apartment Ownership and file their respective Form B. Karnataka Apartment Ownership Act.
50%.
No, my lord, it is not that. It is very clear. The Act does not say for that, does not provide for that. It is only when there are 100% of them make a submission. That is against the Act also. So, my lord, there is a maintenance breach. There is a compliance outrightly. My learned friend says that it cannot be complied. Section 17 cannot be complied. They don't want to comply that, citing some rules and things. There is a central legislation which requires compliance of section 17, and there is a mischief that was proposed to be remedied. The builder retaining the ownership of common areas and mortgaging that property is something which is happening in common.
That could be challenged through the respondent number 5 society.
No, they can't hesitate. They don't have, even they cannot represent before this court. That
exactly answers the query your lordship had.
Hibiscus, my lord, the Supreme Court has clarified that they cannot. And the RERA is very clear, they cannot. And any unregistered body, my lord, cannot sue in their name. It is a settled law, my lord. There cannot be an exemption here, only to facilitate the builder, my lord. And if that was the case, my lord, the very own petitioner would not have defended a case where the owners association under 1972 formed when they themselves filed a deed of declaration. They went to the NCDRC with their grievances, were defended saying that they are not eligible. And the same petitioner here says that cooperative society is not eligible, only 1972 is eligible. This is a mischief, man. And this is a mischief throughout. And your lordship, the 1972 Act associations, my lord, there are, and regarding the, there are only very few number of associations under 1972. 90% of the associations are under Karnataka Societies Registration Act. Because there was no way a 1972 association was, they could not have been registered at all. No builders was registering the deed of.
If you are a cooperative society, you should submit yourself to the jurisdiction of the registrar under the cooperative society.
Yes, my lord.
They appeal to the KAT.
Yes, my lord.
Where is the question of approaching this appellate tribunal?
I have not approached the appellate tribunal.
No,
as an allottees association, I have a right. Any body corporate can approach the RERA. I have approached there, and they obtained a stay behind MAC. When the stay order is in operational, they do all these activities. They transfer the corpus fund illegally because the corpus fund with the corpus fund, my maintenance was to be conducted. They dilute the corpus fund.
See, I can understand your dispute with the petitioner.
Yes, my lord.
Why there is a dispute between?
I don't have a dispute between them. They have a dispute with me. I don't absolutely have any dispute. I am saying, if you are a registered body,
he will make the same submission.
My lord, if they have a registered body,
Good for the society.
Exactly, my lord. That is what I'm saying. We are saying that only
You should, both
former.
of you should join hands.
My lord, I will join the hands provided section 17 can be complied. Section 17,
You can, both of you can agitate your grievance against the petitioner.
everything is there, my lord.
Not amongst yourself.
What about the common areas?
Very sorry
When the
state of
central
affairs.
legislation very clarifies that the common area to be conveyed to the allottees association, and the builder cannot retain its rights there. The undivided interest is fictitious, my lord. That is why there is this section 17 which has come up. All this undivided interest they say, and the common area which is under the FSI and FIR is not conveyed at all. They retain the rights. Then they join into another. The modification is done without my consent. So many mischiefs was being addressed by section 17 compliance and openly against the central legislation, a statute requirement. My learned friend is submitting that section 17 cannot be complied. If 1972 associations can comply section 17, my lord, I don't have an issue. If there can be a registered conveyance deed in their favor.
Yes, excuse.
One point that I want to make is, so far as maintenance is concerned, we are a valid system. And that is why we are focusing on it.
Now you are collecting the maintenance. You are maintaining the building.
Second point, so far as compliance with section 17 methods, nothing stops me from being that association to sign up against it if it were to come to that. And I've explained your option the language. Even partnership act, even partnership firms are not a body constituted of corporate. It is done through the partners. Similarly, I'm a body which is through the members. And if I'm able to get consensus of the members, because what the statute says is the minute DOD is registered, the entire apartment gets submitted to the KOA Act. And therefore, by virtue of that, I'm a registered association. The only issue I see my learned friend has is to say that we are not a registered body, unlike the Cooperative Societies Act, and therefore you can't register a conveyance, which I think is incorrect. The only reason is I'm not, even if UDS were to get transferred, it gets transferred to the members only. Even a Cooperative Society cannot say, I will individually hold UDS because the payment is coming from the members. When the consideration is being paid by the flat owners, even a Cooperative Society, which is a body constitute, cannot say, I will hold this in my capacity. It is held on behalf of the members, which is also a duty that I can perform. I can also hold it on behalf of the members through my own resolutions. There is absolutely, which is exactly what partnership firms do. So therefore, I don't
Submission of form number A. His contention is that the association R5 is not a registered association. It is only a body which cannot agitate the sue or be sued.
I don't know, we have representative capacity. It is a
No.
we are representing on behalf of members. We are not making claims here saying we are a body that can represent. We are doing it through representative capacity, which is why I gave the analogy of partnership firm. Even a partnership firm has to represent those partners. And I as an association have to represent to my members. So that doesn't deter me from signing any conveyance on behalf of, because I'm at the end of the day holding the UDS on behalf of the members. Nobody today, including Cooperative Society, can say I'm holding this on behalf. You not need consideration. When you have not paid consideration for the UDS common areas, how can you say I'm going to hold it? It has to be held on account of the members. It's the same duty I'm performing.
Yes.
And also there are no rules today, my lords. The legislation is to enact some rules to understand how do we combat section 17 in a situation in Karnataka where every builder is selling UDS
appears that their claims are only against the builder, they very well can take all their claims, either the registrar of water society or RERA, and actually that claims. But to force every single owner saying you have to become a member is incorrect. Because today we have 20 or 25 people, that's it.
Why should they support the case for quashing?
Now, how many associations could be there in an apartment?
My lord, now admittedly, my learned friend is saying.
Each member can
No,
constitute.
I'm saying, that is a condition.
Tomorrow there may be other associations, sir.
That is why, my lord,
Few member may be registered under Companies Act, few may be under Societies Act.
no, that is where, my lord. That is why
There is
RERA,
no restriction.
RERA mandates that an association has to be formed when 50% of the allottees have booked their apartment. A builder sleeping over that duty and today coming and agitating that they have subsequently made for their convenience to wriggle out of the provisions of RERA. And when they are doing, after they cannot take advantage of their own default. They are a RERA registered project. They were duty bound to form an association. My lord.
Again and again.
To overcome that, my lord, we have done this. The very mischief what the legislator attempted to fix is out in the open again for the builders to destroy. That is my humble suggestion. Everything. Look at there. They want the 1972 under a representative capacity. They want the conveyance to be made in some person's favor. Instead of in a cooperative society where in a democratic manner, in a democratic form, where the decisions are taken by the majority decision, they don't want that to be happening. They want it in a representative capacity where one person's act make each one of us life. Such kind of a sufficient, my lord, where how can an unregistered association be compared to a party? If it is the same, it is the same.
Suppose tomorrow in your society there may be some irregularities. An administrator can be appointed under cooperative societies.
My lord, it is a democratic process.
Yes, the government will take over.
Why should the government take over? My lord, there is every takeover will the maximum 26 months. There is a law to govern that.
Sir, we are seeing it every day.
My lord, to reduce the burden on this court, should a democratic process, which is my fundamental right to form the cooperative society, it is in the constitution where the cooperative movement is the.
That is what I am saying. See, every 323 members are having the democratic, what is that?
Yes.
They can constitute. They can each 10 or 15 members, they can constitute a society.
Should it be that way or left it to 1 or 2 persons who will under the representative manner they have to represent and they cannot educate, they cannot go to Supreme Court, rather go anywhere. Where they have to go, it will be in the individual capacity. Should it be left
Collectively,
or a democratic process to be there or not?
Collectively, they can go.
Definitely.
Association.
Yes, association can maintain.
Then the Supreme Court was wrong in its own mind.
That is what I want to explain, my lord, how it is incorrect.
The center is wrong. It says that a person should be a registered association.
That is in that particular case, my lord, it is a recognized consumer association. That was the definition. Under the Consumer Protection Act, it was decided. It is not under the RERA. Subsequent to the judgment, RERA has come into play.
The amicus is being appointed in this matter.
No, definitely. I will argue and then the amicus will argue or the court will direct. You are not required to.
Amicus curiae should have
Yes.
addressed the argument.
Yes. And then I will add, because I need to explain the history of these legislation, my lord. Unless otherwise, this confusion cannot be. This can be cleared, my lord. Because I have to start from the 1882. Then I have to end up with this RERA Act, my lord.
My lord,
and only the repugnancy can be whether there is any.
My lord, the entire history has been discussed, my lord, by the Supreme Court. While in the Forum for People versus Forum for People for the collective, People's Collective versus the West Bengal government, my lord. The entire history, my lord, why the RERA was enacted. It has very categorically brought out what are the inadequacies of the state legislations. Why RERA was required. And each and every clause has been in a detailed discussions. Man. A 25-member committee was formed. They visited all over and they were in Bangalore also. Man. All these undivided interest, all these issues, every objections by the aggrieved stakeholders were being considered. Yes, ma'am.
Let him address.
To aid the easy understanding of whatever I submit, the brief facts, the factual background in this case, I just summarized just for the sake of context.
Yes.
So as it is stated in the petition, that is 5934/24, the petitioner had undertaken development of the project and they have obtained the OC on 26/5/2023.
26/5?
2023.
Yes.
And on 12/6/2023, the petitioner has executed and registered a deed of declaration along with the bylaws of the Pristine Owners Association before the sub-registrar. On 21/6/2023, the petitioner has filed copies of the deed of declaration with the bylaws with the first respondent as required under the rules. On 6/9/23, the certificate of registration of the third respondent society has been issued.
Yes.
And this registration was challenged by the petitioner, which was rejected, against which, aggrieved by that, the petitioner is before this honorable court. So the issue involves the application of the regulatory regime regarding apartments. I have submitted a short note before I go into the specific submissions, which I have shared with the other councils also.
Yes.
There are three acts, my lords. The Karnataka Apartment Ownership Act of 1972, which is in short referred to as KOA during course of arguments. Then there is the Karnataka Ownership of Flats, Regulation and Promotion of Construction, Sale, Management and Transfer Act, which is referred to as KOFA generally. Subsequently, the Real Estate Regulation and Development Act 2016, which is now referred to as RERA, has come into place. Now, the Karnataka Apartment Ownership Act provides for ownership of individual apartments in a building and to make such an apartment heritable and transferable property. It deals with all the aspects of the apartment used for residential purposes, including ownership of an apartment and matters related thereto. It is applicable if the owners of the apartment or the promoters submit to the provisions of KOA by duly executing and registering the declaration, deed of apartment and bylaws, and Form B by the subsequent purchasers. That declaration must be registered before the jurisdictional sub-registrar and later filed with the registrar of cooperative societies. Now, the KOFA is an act to regulate in the state of Karnataka the promotion of construction, sale and management of transfer of flats. Under this act, a cooperative society or a company to manage, before that, my lords, the flats can either be residential or commercial as per the act.
As per KOA, it is only residential.
Only residential. As per KOFA, it can either be residential or commercial. That, my lords, I would stress is important that the words used in the act are or, whereas it has been construed as exclusive in the decisions. Under this act, a cooperative society or a company to manage the affairs of the complex would have to be formed and registered. In the case of a cooperative society, it would have to be registered with the registrar of cooperative societies, and in the case of a company with the ROC. The KOFA would be applicable until the apartment is subjected to the provisions of KOA. That, my lords, is also settled law as per the decisions of this honorable court. That till there is a voluntary submission to the KOA Act, by default the KOFA applies. Then, my lords, is RERA. This was enacted by the parliament. Now, both KOA and KOFA are state enactments.
Yes.
RERA is a parliamentary legislation to regulate and promote the real estate sector and to ensure sale of plots and apartments is carried out in an efficient and transparent manner and to protect the interests of consumers. In terms of section 89 of RERA, the act will have effect notwithstanding anything inconsistent with any other law for the time being in force. Now, after that, my lords, is where the controversy starts.
Yes.
Section significantly RERA mandates transfer of common areas in favor of association of owners in terms of section 11 clause 4 subclause F and section 17 clause 1. It is important to note that section 2 clause N of RERA defines common areas to include the land on which the project is executed. Section 11 clause 4 subclause F and section 17 of RERA impose a duty or obligation on the promoter to convey the plot or the built-up area to the allottee and the undivided proportionate title in the common areas to the association of allottees or competent authority, as the case may be, as provided under section 17 of the Act. On a combined reading of section 2 clause N, section 11 clause 4 subclause F and 17, it appears that as per RERA, the apartment plot building must be conveyed to the allottee and the undivided proportionate title in land in which the said building or apartment is constructed must be conveyed in favor of the association of allottees or the competent authority. A reference is made to the local laws for the purpose of identifying the time frame within which the transfers must be completed. Now, the implications of all these three enactments, my lords, are under the KAOA Act, just to summarize, the undivided interest in land is to be conveyed along with the apartment to the individual allottee in terms of the deeds contemplated under the KAOA. COFA, the land and the apartment building would have to be conveyed to the association of allottees completely, that is either cooperative society or company, in terms of section 10 and 11 of COFA. It contemplates a scheme whereby individual allottees would be entitled to enjoy the units as part of the association. RERA mandates that the apartment building would be conveyed to the individual allottee and the project land would be conveyed to the association. These three enactments put in place different modes of ownership of apartments, buildings, or flats. In view of the overriding effect of RERA, that is what the counsel for the respondent is arguing. In view of the overriding effect given to RERA in section 89 and provisions of Article 254 of the Constitution, it appears that central legislation would prevail over state legislation if they both operate in the same matter. Entries 6 and 7 of the concurrent list.
Yes.
Thus, if it is held that it is 6 and 7, KOA and COFA after commencement of RERA would apply only to such projects which do not fall within the purview of RERA in view of section 88 of RERA. Section 3.2 excludes application of RERA to the projects which involve development of land measuring 500 square meters or projects where number of apartments proposed to be developed is less than 8. It also excludes projects which are completed and those which involve only renovation and repair without involving advertising and selling of units. Under the rules formulated by the state pursuant to the provisions of RERA.
What is meant by project completed?
OC, my lords. RERA defines it as issuance of occupation certificate or completion certificate.
Not execution of sale deed in respect of all the units.
No, it says specifically. The rules also interpret what is completion by stating that if so many extents of sale deed is executed or common area is handed over, it is deemed to be completed for the purpose of RERA. That means for application of the provisions of RERA. I'll point that out also, my lords. Under the rules formulated by the state pursuant to the provisions of RERA, the owners association must be a registered association. Thus, as such, only a company, LLP or cooperative society appear to be contemplated, but are not expressly specified, leading to ambiguity as technically even an association of persons could be constituted on a deed registered with the sub-register. In case of 200 or more units, by virtue of application of Companies Act, only a company or a cooperative society is permissible. Even in a cooperative society, there are various difficulties, my lord. That is only by way of abundant caution in terms of restrictions. For example, in a cooperative society, only membership can be of only one society. This is under the restrictions under the Cooperative Societies Act. A person can be a member of only one society and not multiple societies.
No, where this restriction only in case of units being above 200, only a company or a cooperative society.
That is under the Companies Act, my lords. There is a provision which says that any association of persons beyond so and so must be organized as a company. Cooperative Societies Act specifically does not restrict the number of members of the association, whereas for a private limited company or an LLP, the maximum number permitted is 200. But insofar as an LLP is concerned, there is some ambiguity, my lords. But generally, above 200, as per the Companies Act, it has to be by way of a company. Statutorily, under the Cooperative Societies Act, there is no restriction on the number. Therefore, either a cooperative society or a company is permissible. Otherwise, the Companies Act specifically uses that any association of persons beyond 200 must be by way of a company or registered under some other act. That is independent of this dispute. Under this, drawbacks of a cooperative society, my lords, in the context of ownership are: one, a person can be a member of only one society and not multiple societies. There is a restriction on holding more than 5% without government permission. These are all restrictions under the Cooperative Societies Act. Management is liable to be superseded by the government. There is restriction on voting till completion of 1 year and only one vote per person, irrespective of number of extent held. Then provisions are there which permit cancellation of membership, whereby ownership of the land itself can be divested. Then there are difficulties in obtaining loans as only shares are owned and not properties, whereas collateral cannot be done. And then additional stamp duty if land and common areas are to be conveyed to the society. These are all the difficulties of a cooperative society. Now, in the present context,
Yes.
All the earlier decisions, the division bench decisions and the Supreme Court decisions, everything was considered by the coordinate bench. In Akhilesh Anand's case, all of them have been dealt with. All the earlier decisions of the division bench have been interpreted by this honorable court, stating that they do not take into consideration the impact after RERA, and therefore conclusions have been drawn by the coordinate bench. Now, I would invite my lord's attention to this Akhilesh Anand's decision that appears to be directly addressing many of the questions.
You can continue at 2:30.
Yes.
How much time am I required?
Another 15-20 minutes, because I'm pointing out those decisions.
I need another 15-20 minutes, my lord. The reason is that, my lord, the repugnancy which I have to address, for that reason I need some more time, 15 to 20.
ಆಯ್ತೇನ್ರಿ ಊಟ? ಅದೇನ್ ಸ್ವಲ್ಪ ಹೊತ್ತು ಆಗ್ಬೋದು ಅಷ್ಟೇ, ಇದೇ ಜಾಸ್ತಿ ಹೊತ್ತು. ಗೊತ್ತಿಲ್ಲ ಸರ್, ಇನ್ನು ಈಗಲೇ ಮುಗಿಯಲ್ಲ. ಗೊತ್ತಿಲ್ಲ, ನೋಡೋಣ. ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್ ನೋಡ್ತಾ ಇರಿ. ತಿಲಕ್ ವಕಾಲತಿಲ್ಲ ಅಂದ್ರೆ ಹಾಕಕ್ಕಾಗಲ್ಲ. ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು, ಅದಲ್ಲೂ ಆಗಿಲ್ಲ. ಎಚ್.ಎನ್. ಬಸವರಾಜು R11 ಇದ್ದಾರೆ ಆಲ್ರೆಡಿ. R18 ತಿಲಕ್. ಅದು R11 and R7. ಅವರು 7 ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. ಸೇಮ್ ಅಲ್ಲ, ಪಾರ್ಟಿ ಸೇಮ್ ಇರೋದ್ರಿಂದ ಹಾಕಿಲ್ಲ ಅವರು. ರವಿ ಬರ್ತಾ ಇದ್ದಾರೆ. ನಾಳೆಗೆ ಎಷ್ಟಾಯ್ತಂತೆ ಮೆಸೇಜ್ ಹಾಕಿದ್ದೀನಿ. ನಾಳೆದು ಪಾಠ ವಾಟ್ಸಪ್ ಮಾಡಿದ್ದೀನಿ. ಪಾಸ್ವರ್ಡ್ ಇನ್ನೆಲ್ಲೋಯ್ತು? ಪೆನ್ ಪೆನ್ ಪೆನ್. ಮತ್ತೆ ಆಗಿದೆ. ಎಸ್. Counsel for the petitioner and respondent praise button. This time, ಯಾವಾಗ? Tomorrow? 11th or 12th ಭಾಳ ಇದೆ ಸರ್. 12th ಸ್ಟೇ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್. ಮತ್ತೆ ಆಗಿದೆ. ಆಯ್ತು. ಯಾವುದು? ಈಗ 9 ಅಲ್ವಾ? ವಿ ಆರ್ ಹಿಯರಿಂಗ್ 9. ಅವರು ಇವರಲ್ಲಿ ಮಧುಕರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಮಧುಕರ್ ಎಂ ದೇಶಪಾಂಡೆ. ಅಲ್ಲಿ ಅವರು ಇದ್ದಾರೆ.
So you may require 15 minutes. 15 minutes, half an hour ಆಯ್ತು. Then list number 2 ನಲ್ಲಿ ಎಷ್ಟಿದೆ?
List 2 ma'am. 10.
10 ಇದೆ. Other matters ನೋಡಿ ಇದು 11 to 11 onwards, serial number 11 onwards.
Matters, my lord, it should be disposed, matter.
16 to
16 to 21, my lord.
20 already ಹೋಗಿದೆ, 21 ಅದಷ್ಟು ಇರಲಿ.
Please,
Uಳಿದ
please.
matters.
Please.
16 to 21 ಇರಲಿ. Other
11 to 15.
Yes.
Serial number 9, Madhukar M. Deshpande.
Yes.
Before I continue, the answer to the question of the coordinate actually is correct. 100 under section 464 of the Companies Act, it says no association or partnership consisting of more than such number of persons as may be selected to form for the purpose of carrying on any business that has as its object and position of made by association or partnership or by individual members unless it is registered as a company under this act or is formed under any other law for the time being. Provided the number of persons will not exceed 100. That means association or partnership for business or gain in any manner of the fund of the association or individuals, unless it is below 100, it should carry on as a company registered under this act. A private company can have 200 shareholders. Above that, has to be a public company.
Which is the provision here
464
of Companies Act?
of Companies Act 2013. Under that section, my lord, there is a notification. Under the Companies Mysterious Rules 2014, where Rule 10 provides.
Companies Act.
Rule 10 provides that the number of persons to which it is restricted to is 50. So, effectively, by virtue of this section and this rule, above 50, it should be in the form of a company unless it is registered under some other act.
There is no such restriction under RERA or KAOA. So under KAOA only, it will be considered as registered once the declaration form is submitted.
My lord, they have to be considered because what it says is under any law. The general interpretation of under any law is whether cooperative society, company, etc. This is only a registration under the registration act.
No, under not reference with reference to 464. Generally, under KOA, submission of the declaration by the owners, it amounts to registration.
No, my lord, the Apartment Ownership Act, it specifically provides in section
There is separate registration.
13, section 13, what the respondent referred to. 13 clause 1. The declaration and all amendments thereto and the deed of apartment for each apartment and the floor plan of the building referred in subsection 2 shall be registered under the Registration Act 1901. And it provides that the separation should maintain a separate register of books for apartments, etc. So a register, the clause 5 members, 13 clause 5. Separation or as the case may be, registrar shall register the declaration along with the floor plans of the building and the deed of apartments in the register of declarations and deed of apartments under the apartment of 72. And shall also enter particulars in index chapter under the subsection.
But whether it will be considered as an registered association,
So that my lord would be definitely a subject matter of interpretation, because here the powers of the owners association is also specified under the act. In fact, section 6.
in any of the decisions that are relied on by both the parties, any of the courts have held that registration under 13(1) amounts to an association registered as required under law.
It's the other way. The decision is application state recognizes the fact that this registration is permissible, but it identifies the circumstances under which it will be.
No, the specific contention raised by respondent number 3 is that it cannot be considered an association registered, so it cannot sue or be sued.
That contention is upheld in the decision. Following the Supreme Court decision which is relied upon, the court upholds the decision that
Affiliation.
affiliation. I
Yes.
point out that.
Yes.
Just a short mention before I go to affiliation, and I come back to it in detail. The Supreme Court decisions forum for people's collective will be relied upon by the respondents. That is in the context of the repugnancy between the RERA Act and the West Bengal
Yes.
Regulation Act. And in that specific context, the court has identified under what both the enactments are on in the concurrent list, item 6 and 7. Therefore, by virtue of 254, if it tries to occupy the same field, then unless there is presidential assent, the central enactment will prevail over the state enactment.
Yes.
And it has identified 3 tests for repugnancy. And specifically, there is a finding in that decision that the West Bengal Act is repugnant to the RERA Act.
Yes.
So that is material for the purpose of concluding if the court comes to the conclusion that there is repugnancy, what is the impact? Otherwise, it cannot have a direct bearing on whether RERA is now appointment or impact is repugnant, because the enactments are different. In the Akhilesh Anand's case,
Yes.
in Akhilesh Anand's case, Manoj, at page 143, the points which are specifically considered is listed out.
Yes.
90, the points directly and what would be material. First question, whether an association of authorities contemplated under RERA 2016 will include an association formed under TOI 1972, or would the association of authorities be different from an association under TOI 1972?
Yes.
2, whether an association under TOI 1972 can be formed by authorities before conveyance in their favor by the developers. 3, whether there is any conflict between TOI 1972 and COFA 1972 on one hand and RERA 2016 on the other. If so, which enactment would prevail? 4, whether an association under TOI 1972 can initiate proceedings under RERA 2016 2016, more so in relation to section 31 of RERA. 5, 6, 7 are all specifically in the context of the facts in that case. Point 1 and 2 are answered together by us.
Yes.
From para 21 onwards. The answer to this question, my lords, is at page 163. Para 21.27. Last paragraph of page 163.
Yes.
21.27.
Yes.
Hence, I answer point number 1 by holding that the association of allottees conducted under RERA 2016 will not include an association formed under TOA 1972 or a society under PSRA 1960.
Yes.
28. I answer point number 2 by holding that the association of allottees contemplated under TOA 1972 cannot be formed by the allottees before conveyance in their favor by the developers. No declaration being capable of being submitted by them. In arriving at this conclusion, the court has considered the division based systems also, which is relied upon by the other respondents. At page 157, specifically. My lord prefers I could take my lord through the process of the conclusion at the reasoning which is arrived
Yes.
at. It may answer several of the questions.
Yes.
It starts from page 145, 21.1.
Yes.
Both the above points being related to each other are taken up together for consideration. The crux of the matter in the present petition is who is to represent the interest of the allottees in whose favor no sale has been excluded. That is to say, allottees being those in whose favor an allotment letter or agreement of sale has been excluded, there being no sale rate which has been excluded. The issue involved in the present matter is one which is not only faced when a real estate project is implemented in phases, the initial phase being completed early. And in such cases, as regards the completed apartments, the developer was to exclude registered sales. Insofar as the buildings which are to be constructed subsequently in subsequent phases, there being a time lag between the initial phases and subsequent phases, there could be a situation where due to substantial time lag, interest of persons in whose favor sale rates have been excluded, interest of persons in whose favor only allotment letters or agreement for sale have been excluded would clash, and there would be a requirement to balance the interest of all. In the present case, as could be seen, there are 5 towers. These are all specific facts. Different towers. There are 21.6 towers. Next, page 1.8.
Yes.
The RERA being of the opinion that an association registered under KSRA 1960 is not one, this could be said to be an association of allottees in terms of RERA 2016, directed them to register a cooperative society under KSCA 1959. Register of cooperative society is not having registered, same a positive direction came to be issued in persons of which the cooperative society had been registered. As such, the cooperative society has taken up the claims and complaints against the developer. It is in this background that the following entities emerged as players in this, for lack of a better word, drama. The first being the developer, second being the society formed by the purchasers of apartments in whose favor sale rates have been executed, which is the petitioners. Third being an association of allottees whose apartments have not been completed, who also registered under KSRA 1960. Fourth, the cooperative society which had been formed as per directions of RERA and the RERA itself. The association of allottees has not been defined. However, subsection 3 of section 19 makes a reference to the association of allottees. And allottee has been defined under clause 3 of section 4 of RERA, which reads as under. Allottee in relation to real estate project means the person who bought, contract or building as a case may be has been bought, sold, whether as freehold or leasehold, or otherwise transferred by the promoter, and includes a person who subsequently acquires said allotment to sale, transfer or otherwise, but does not include a person to whom such plot, apartment or building as a case may be is not made. A perusal of the above provision would indicate that an allotee in relation to a real estate project would mean a person to whom a plot, apartment or building as a case may be has Section 19 deals with the rights and duties of authorities, which is reproduced herein for easy reference. Here, my lords, the material provision is 9 in page 152, which is in bold. Every authority of the apartment, lot or building as a case may be shall participate towards the formation of an association or society or cooperative society of the authorities or a federation of the same. 21.1. A provision of the above provision would indicate that an authority would be entitled to obtain the information relating to the project, know the stage-wise time schedule of completion, and claim possession of the apartment's lot or building with the association of authorities being entitled to claim possession of the common areas. The manner and methodology of formation of association of authorities is as contained in clause E of subsection 4 of section 11 of RERA, which is reproduced herein for regular reference. 11.4. The promoter shall enable the formation of an association or society or cooperative society as a case of the authorities or a federation of the same under the laws applicable, provided that in the absence of local laws, the association of authorities by water and impact shall be formed within the period of 3 months of the majority of authorities are moved their plot or apartment or building as a case here. In terms whereas the obligation is on the promoter to enable the formation of an association or society or cooperative society as the case may be of authorities or a federation of the same under the laws applicable, and unless the local laws otherwise prescribe, such associations will be formed within a period of 3 months of the majority of authorities having moved their plot or apartment or building as a case may be. Thus, even clause B of subsection 4 of section 11 does not specify the nature of association, but only indicates that the promoter shall enable the formation of an association, society, or cooperative society. It is this which has caused the confusion in as much as an association could be one under KOA 1972, a society could be under KSI 1960, a cooperative society could be one under KSCA 1959. It is in that background that the petitioners contend that an association under KOA 1972 is required to be formed to handle the maintenance of the building and not a cooperative society under KSCA 1959. Respondent number 7 to 15 contended that there is not only maintenance of the building which is being considered and acted upon, but also the claim against the developer for not complying with the obligation is repeated. The submission in this regard is that an association under KOA 1972 can only be formed by the owners of the respective apartments after registration of all the apartments is complete. The project not being complete, registration of apartment not being complete, no association under KOA 1972 can be formed. It is this factual background which has given rise to legal parameter which is required to be implemented. If it has to be held that an association could be a society under TSI 1960, the division bench of this court in VDB Calendon's case and in DSN's case has categorically come to a conclusion that a society registered under the TSI 1960 cannot have as one of its objectives maintenance of an apartment complex, and the division bench of this court has come to a conclusion the above matters that it is only an association under TOA 1972 which can maintain an apartment complex. A society registered under the TSCA 1959 is mentioned in the COFA 1972. However, this court in Starless Apartment Owners Cooperative Society Limited has come to a conclusion that the cooperative society can only be formed if in the building there are no residential and commercial properties. That is, if there are no commercial properties in the said building, a cooperative society cannot be formed for the purpose of maintenance of the building. The decisions in VDB Calendar, DS Max, Starless Apartment Owners Cooperative Society Limited, and Shantaram Prabhu case were all rendered in the situation where RERA 2016 was not made applicable. And what was under consideration in all three matters is as to who can maintain an apartment complex in the absence of RERA 2016 being applicable. As indicated in the provisional clause E of subsection 4 of RERA, in the absence of local laws, the association of authorities by water being formed shall be formed within a period of 3 months of the majority of authorities having booked their plots or apartments or building as the case may be. And towards this end, the promoter is required to enable such formation of association of authorities. The requirement being to form an association of authorities within 3 months of the majority of authorities having booked their plot, apartment or building would categorically take away an association under KOA 1972, since such association under KOA 1972 cannot be formed without a deed of declaration by all the owners of the property, with ownership arising only after registration of a sale deed in their favor. Section 5 of the KOA 1972 is reproduced here for easy reference. 1. Each apartment owner shall be entitled to the exclusive ownership and possession of his apartment. Each apartment owner shall execute a declaration that he submits his apartment to the provisions of this Act and a deed of apartment in relation to his apartment in the manner prescribed for the purpose. The reading of subsection 2 of section 5 will indicate that each apartment owner shall execute a declaration that he submits his apartment to the provisions of the Act and deed of apartment in relation to the apartment in the manner as prescribed for such purpose. The association of apartment owners is defined under clause D of section 3 of KOA 72. Association of apartment owners means all of the apartment owners bylaws and declaration. A perusal of the above would indicate that such association would mean all the apartment owners acting as a group in accordance with the bylaws and declaration. Thus, as indicated supra, an apartment owner would have to execute a declaration. Such ownership would be determined only on the basis of registered statement in favor of such person, and the association would be of apartment owners, thereby clearly indicating that an allottee would not be an owner and therefore would not subject his apartment to a declaration, thereby not form an association. In view of the above, on account of the decisions of the division bench of this court, a society cannot maintain an apartment and an association of owners cannot be formed under POA 1972 unless there are registered statements in favor of the owners. A cooperative society cannot be registered under POA 1972 without there being a commercial unit in the building. This brings us back to the question as to what is the composition and or nature of the association of authority as contained under clause E of section 4 of subsection 4 of section 11 of the Again, as indicated supra, in all the decisions of the honorable division bench of this court, when the issue as regards maintenance of apartment is considered, they were considered without reference to RERA 2016. I have also considered this issue in Shantaram Prabhu's case supra dealt with the applicability of COPA 72 and POA 1972. However, by doing so, I have clearly stated therein that RERA 2016 has not been considered and this would have to be considered at an appropriate time in an appropriate manner, at a manner which has arisen in the present case. In the present matter, the applicability of RERA 2016 is required to be considered, since it is the association of allottees who are required to approach RERA for necessary orders, and it is the association of allottees who can take claim to the common areas and amenities, with the allottees being able to make claim only as regards an apartment flat or building allotted to the said allottee in first place. The functioning of the association of allottees is not in as much as maintenance of the building, but is more as regards to the claim made by allottees to their association against the promoter developer as regards to the differences and efficiencies in implementation of the project. Thus, the decision in Starless Apartment Owners Cooperative Society Limited, which was dealing with maintenance and held that unless a commercial unit of present in the building of cooperative society cannot be registered as a COPA 72, would not be applicable to a project which is being implemented in different phases where the association of allottees intends to take up their defense against promoter developers. Hence, by logic of elimination and deduction, the association of allottees which intends to take up their defense against the promoter would not be covered by the above decision. It is clear that the association of allottees under clause E of subsection 4 of section 11 would not include an association formed under POA 1972, would not be a society under PSI 1960, but can however be a cooperative society formed of the owners of the allottees who are yet to acquire ownership in order to extricate their claim against the promoter developer. This answers point 1 and 2. So what the court has identified is that principally the definition of allottee under RERA includes people who have just been allotted but not have been conveyed. And because under RERA there is an obligation to form an association of allottees. That allottee need not be an owner, whereas under the Apartment Ownership Act they have to be an owner. Therefore, what is contemplated under RERA cannot be what is there under 1972. That is the reasoning. The next point is the issue of conflict between the two enactments.
Yes.
That is, whether there is any conflict between KY 72 and COPA 72 on the one hand, and RERA 2016 on the other. If so, which enactment will do it? Here again, my lord, the conclusion drawn eventually is that RERA and COPA are inconsistent, and therefore RERA will prevail over COPA. But the court words that it is not inconsistent with Apartment Owners Act. I'll read through so that the logic is. Though several submissions have been made by all the counsels in this regard, and there are several decisions which have been cited in this regard. All the decisions which have been cited are once either related to POA 1972, COPA 72, and the interplay between them. None of these decisions deal with all the four enactments, that is KOA, COPA, RERA 2016, as well as the interplay between them. As indicated Subra and Shantaram Prabhu's case, this court has also observed that the aspect of RERA 2016 was not considered there, since the project in question was not a project subject to RERA, since the same had been implemented prior to RERA 2016 coming into force. Insofar as projects which have been implemented prior to RERA 2016 coming into force, and or project as regards which RERA 2016 is not applicable, then in such a situation, insofar as maintenance is concerned, it's KOA 1972 which would be applicable, and insofar as dispute between allottee and developer is concerned, it's COPA 1972 which is applicable. With With the promulgation of RERA 2016, once a project is made subject to RERA 2016, it is the rights and obligations that RERA 2016 which should prevail, and it should be applicable to the allotee association of allottees, owner of apartment as well as promoter developer. Again, as indicated supra, KAO 1972 would only be applicable as regards maintenance of the apartment complex with the owners subjecting the respective apartments and the common interest by way of declaration, which is deed of declaration by executing the deed of declaration and the forms in support thereof, which should be registered to the Register of Assurance. The said deed of declaration also contains the manner and methodology of establishing an association of owners and the bylaws applicable there. Thus, looked at from any angle, an association under KAO 1972 can only be formed by the owners of the apartment and not by the others. OPA 1972 has been dealt with in detail in Shantaram proposal case, and the conflict, if any, between KAOA and OPA 1972 has been considered there. It has been categorically held that until the completion of the building, OPA 1972 would be applicable. After completion of the building and execution of said dates, insofar as maintenance is concerned, KAOA 1972 would be applicable. With the entry of RERA 2016, RERA 2016 addresses the interests, rights, duties, liabilities, etc. between the allotee owner and the promoter developer. RERA 2016 in most cases would be applicable until the project's completion and for a few matters even after the project's completion. RERA 2016 deals with the relationship and interstate disputes as aforesaid, which was earlier dealt with to a limited extent by COPA 70. In my considered opinion, RERA 2016 would prevail over COPA 1972 regarding any project that has been subjected to RERA 2016. More so since RERA contains non-abstracted provisions indicating that it prevails for any other project. As regards KAO 1972 and RERA 2016, KAO 72 can only come into being if all the owners subject their apartments and common areas to a deed of declaration in accordance with KAO 1972. Insofar as the construction phase is completely concerned, until the completion of construction, KAO 72 would have no role to play, and as such, it is RERA 2016 which would address all these issues. Since I answered point by holding that there is no conflict between KAO 1972 and RERA 2016. In as much as RERA 2016 is applicable to pre-ownership, KAO 1972 is applicable to post-ownership. Insofar as COPA and RERA 2016 are concerned, there is a conflict. However, RERA 2016 would override COPA 72, and it is the rights and remedies which are provided under RERA 2016 which would override those under COPA 72. On completion of the building, RERA 2016 being applicable in respect of certain aspects, KAO 1972 being relating to maintenance, RERA 2016 also providing warranty as regards construction which is being done. There could be some overlap between RERA 2016 and KAO 72. But however, at that stage, it could be the association under KAO 1972 which could activate its rights under RERA 2016. Since an association under KAO 72 can, as head by division bench, so it's not be competent association to handle all aspects related to maintenance of the building. So the distinction is what we made post completion and during pregnancy of completion, and in that context, KAO is applicable to post, therefore there is no conflict. Then, my lords, the answer to the question on whether association can initiate is considered in the next part. Some of the aspects touching upon this point have been dealt with in point 1 to 3. I have clearly and categorically come to the conclusion that no association can be formed under KAO 1972 unless ownership is transferred to the apartment owners. Proceedings and RERA 2016 are normally initiated with regard to any points as part of promoter. Section 31 of RERA reads as answer. Any other person can file a complaint. Reading of subsection 1 of 31 would indicate that any other person may file a complaint with the authority or adjudicating officer as per the expression of subsection 1 of 31. The person shall include the association of allottees or any voluntary consumer association registered under any law for timing. Alterations of RERA 2016 rules and regulations are more often than not related to construction, implementation of the project and are filed against promoter developer. The Honorable Apex Court in the case of Augustus condominiums case has held that an association under KAO 1972 is not a voluntary association, but is an association which has come into being on account of compulsory requirement of mandate thereof under KAO 1972 and rejected a claim made by such an association under KAO 1972 against the developer. As per the explanation of subsection 1 of section 31, a person would include an association of allottees or any voluntary consumer association. As held in Hibiscus condominiums case, an association under KAO 1972 would not be a voluntary consumer association, and as held supra, an association under KAO 1972 cannot be formed without ownership being transferred, that is without the project being completed, and as such an association of allottees would be an association of persons who are allottees of apartments where registration of safety does not apply. Thus, I answer point 4 by holding that firstly, an association under KAO 1972 cannot be formed without ownership being transferred, which more often than not is done only after project is complete. An association under KO 1972 being formed out of a compulsory mandate under KO 1972. Such an association is not a voluntary consumer association as held by one of the ethics code in convenience case. And as such an association under KO 1972 usually formed by owners before the project is completed, so it cannot make it living. This, my lords, is essentially the conclusion from. Then regarding the other players, my lords, I just read out certain paragraphs which are material in the context of the 24.9, page 179. Prayer number 6, being for issuance of directions to the developer to take necessary steps for formation of association and KO in 1972 would also not arise for the reason that ownership of apartments is yet to be transferred. Allotment having already been made, unless all allottees are to join, the question of directing the private developer to register an association would not arise. It will always be left open to the owners of the various apartments to come together with the developer to form an association under 72 for the purpose of maintenance of the apartment complex. Then 24.11. Prayer number 8, being an omnibus prayer to direct all the respondents to extend support and cooperation for formation of an association of apartment owners, again cannot be issued for the very same reason as stated in my answer to prayer 6 and 7. Such an association of owners can be formed only after statements are excluded by the owners and they come together to form an association. Of course, since at this point I will just highlight it. Since a declarative affidavit has been executed by all the allottees at the time of entering into an agreement of sale, they would be bound to be a part of single declaration of the KO 1972 and register themselves as an association under KO 1972. Then, my lords, para 25.3 at page 184. Whether on registration of corporate society could the registrar initiate proceedings against the petitioner for cancellation and such registration or issue directions not to carry out maintenance of common interest. The answer is hence I answer point number 6 by wording that as held by this court in the decisions of PDB Celadon Apartment Owners Association DS Max RS Shantaram Prabhu case, a society registered with KSI in 1960 cannot carry out any maintenance activity of an apartment complex even if it may be only that of common areas. This aspect is brought to knowledge of the register. It will be about this is a society registered as a charitable society under the 1960 Act. Not the cooperative society which is 1959.
That is Registration Act, KSRA.
No, my lords, that is Karnataka Charitable Societies Act, 1960, where the object was completely charitable. Then, my lords, question 7. Whether a direction could be issued by the court directing developer and all the apartment owners and agreement owners to form an association under KO 1972. Answer is at page 188, 26.5. Thus, I answer point 7.
Yes.
By holding 1, if the developer would also be a landowner and no sale deeds have been executed in favor of anyone, the developer could subject the entire apartment complex to KO 1972 and register an association along with bylaws. 2, if the development is on the basis of a joint development agreement with the land being owned by someone else, then it is the landowner along with the developer who can subject the entire project to KO 1972 if there is no deed of conveyance executed in favor of any of the allotments. In the event of any sale deed or deed of conveyance being executed in care of any of the allotments, then in both the cases, the owner of the apartment used for the registered field has been executed. Also have to join the deed of declaration for the purpose of forming an association. In all three situations above, all the apartments would have to be subjected to the deed of declaration, including all common areas. The above obligation being in terms of declaration already executed by agreement holders at the time the agreement was executed in the this is a contractual obligation on the part of all the parties. There could be no direction in the nature of mandamus issued by the court directing private parties to subject them to deed of declaration. Then, my lords, there are certain observations made from page 195. 28. These observations directly address the confusion of the Interplay on that.
Yes.
28.1. As indicated, Sutra, present litigation has arisen on account of the new enactment, namely RERA 2016 being introduced. Prior to that, it was the KOA 1952 or COFA 72 which are applicable to any aspect related to an apartment. COFA 72 was relating to any dispute between the allotee and directors, rights of both parties having been enumerated in COFA 72. Agreement party could escalate any grievance under the said act. KOA 1972 provides for an association of apartment owners. Such an association could be formed only by the owners of apartment as indicated. Apart from KOA and COFA, any person agreement should always approach civil court of competent to seek for such relief as may be possible, unless there is an alternative dispute resolution provided for contract. With the advent of RERA 2016, the said act encapsulates various rights and obligations of allotee developer and the public, as also provides for grievance redressal mechanism under the said act. RERA 2016 though provides for an association of allottees, there is no methodology which has been prescribed under RERA 2016 as to how the said association can be formed, what would be the legal status thereof, as also under what enactments such association has to be registered. It is in that background that the petitioners are contending that the society could be registered for maintenance of an apartment complex. A co of the society that is not number 8 could not be registered for maintenance, and that co of the society cannot estate rights under RERA 2016 and also meet in common. This has given rise to a situation where though a cooperative society of allottees can be registered under KSCA 1959, the said co of the society cannot carry out maintenance activities. Petitioner number 59 being a society registered under KSRA 1960 cannot carry out maintenance activities. No association of owners can be formed under KOA 1972 since several of the apartments have been conveyed by registered deed and several of the apartments are still at the allotment stage. Thus, giving rise to a catch-22 situation where there is no one who can maintain the apartment common areas and common amenities, while the cooperative society is treating the rights of allottees as against from the developer. Under RERA 2016, the common areas are required to be owned by the association of owners. Again, an association under KOA 1972 would not have the requisite legal characteristics to be registered as owner of such common areas. The cooperative society having requisite characteristics being formed within 3 months of the majority of apartments being sold. The said cooperative society could also be the owner of these common areas and amenities. In my considered opinion, both the Union Law Commission and also State Law Commission have looked into these aspects and removed plan clarification apart from that has been made by the court in the present. Though there is an obligation imposed on promoter developer to enable the registration of association of allottees which has to be done within 3 months of allotment of majority of apartments, it is only the promoter developer who has all the details. The allottees who do not know each other cannot come together to form such an association. In that background, it would be probably required that an association is formed at the time of launch of the project, all allottees joining in as and when allotment is made. Hence, words. Therefore, my lords, what the that holds specifically is that KOA 1972 cannot be formed until all the owners join. Second, RERA
All andre all 100%.
All 100%. I will also point out another decision which varies from that.
Yes.
It holds specifically that RERA contemplates something which is different from what is there under the Apartment Ownership Act, because allottees are involved in the association under RERA, whereas under the Apartment Ownership Act it has to be only owners. And since the specific mandate is immediately after majority of the allottees are identified, association has to be formed. It cannot be apartment ownership act because they have to be owners. So, for example, applying it in this case where it is 395. So, 190 roughly. The moment it crosses 190 or more, there is an obligation cast on the developers to form an association of allottees.
That is 50%.
50%. So in that situation, since allottees association is required under RERA, it is not the same as apartment owners association contemplated under 72. So effectively, if I may take the liberty of summarizing, the court identifies that at any point of time, there can be two different entities. One, whatever is contemplated under RERA, which has a specific objective of protecting the allottees' interests and in their disputes against the promoter. And another is possible for maintenance of the apartment complex, which can be done later by all the owners coming to it. Therefore, the court holds that there is no repugnancy between RERA and AON. But because COFA operates in the same area which RERA operates, it is repugnant and therefore RERA will prevail over.
Yes.
That, in summary, that would be the broad conclusion. But I will also point out certain difficulties with the conclusions.
Yes.
The decision referred to by the respondent number 5, which is the division bench decision, Starnest apartment owner case, but that is 564 of 2024. With the 564 of 2024.
Yes.
Pilots may take note of the fact that insofar as Akhilesh Anand's case is concerned, there is a specific observation by the coordinate bench that all these decisions are without reference to RERA or pre-RERA. Here, pilots in Interplay 564. Para 6. There is a specific submission. Government Council for Applied submits that DS Max Harness is registered under provisions of Real Estate Regulation 2016 in compliance of section 11(4)(e)(f)(g) and 17 of RERA. It is valid to form society. Now, in para 10, where the court considers the submissions,
yes.
Para 10 members. The project DS Max Starnest is registered under RERA. The project consists of residential units only. So the specific factual matrix in that case was that that project was also registered in RERA. But the way the question has been framed by lords, para 16.
Yes.
Para 16, my lords, at page 14 of the document. The narrow dispute in the present appeal is whether association is to be formed under the Act of 1972 or the cooperative society is to be formed under the COFA Act 1972. So the division bench, in coming to the conclusion, does not consider the issue of whether RERA mandates a society. It is considering the issue of COFA, cooperative society under COFA. But interestingly, my lords, para 16.
Yes.
The contention of the learned council for the that include the project being registered under provisions of RERA in compliance with section 11(4)(e)(f)(g) of RERA, a cooperative society is not acceptable. The said provisions of RERA would mandate the builder to enable formation of association of society or cooperative society as the case may be of the parties. As the project under consideration consists only residential units, the said provisions only mandate formation of association of allottees under the applicable laws. The law applicable in the present case is the Karnataka Apartment Ownership Act. This, on a plain reading of the decision, would indicate that because they have referred to RERA, they are considering RERA also. But the specific question which is framed is only whether apartment ownership act or flats act will apply. Yes, my lord, there is another court bench decision which I'd like to bring. This is WP 3779 of 2023. My lords, before I part, this Akhilesh Anand's case, there is a writ appeal filed, WN 1347 of 25. It is pending, there is no interim order as far as I could tell.
Yes.
In WP 3779 of 2023, which I've just handed over the cards.
Yes.
This, my lord, can notice 28 February 2025, and Akhilesh Anand's case is 30th June 2025. So this is prior to the Akhilesh Anand's decision. Here also, my lords, the contentions are more or less whether the apartment ownership act will be formed, etc., etc. And para 17 of the judgment. The honorable court in this case also refers to all the decisions, that is Clarendon's case and Arnest's case. And in para 17 holds, in the light of the decision stated supra and considering the provisions of the KAO Act, it can be safely held that the list stands covered and the petitioners and members of the association are entitled to be registered under the KAO Act, and that there cannot be any association registered under the 1959 Act to form a society to manage and maintain the property comprising of only residential flats. It is also relevant to state here that the COPA 1972 Rule 75 are applicable to the property as both commercial and residential units. In this particular case, my lords, the direction is that
para 18 also.
in the instant case, the project does not include any commercial units, as such the COPA has no application. And since COPA has no application, the registration under 1959 Act is not possible. It is relevant to state that respondent number 4 is the association of owners of flats situated in an apartment for which specific enactment KO Act has been enacted, and therefore registration of association has to be made under KO Act. So again, this is a situation where the project is RERA project. The deed of declaration is executed in 2021. Para 10 onwards, my lords, is the reason.
Yes.
This court has carefully considered petitions also. Section 2 of KOA deals with the application of the Act. The provision in Section 2 of the KOA Act specifies that no property shall be submitted to the provisions of the Act unless it is mainly used or proposed to be used for residential purpose, clearly indicating that KOA Act will only apply to an apartment where it is used for residential purpose. The project referred above is for residential units. Petitioners are purchasers of apartments and deed of declaration is duly executed and registered by the petitioners, along with the other apartment owners, as undertaken to subject themselves to the provisions of the Act. Even assuming as per the contention raised by the respondent that the deed of declaration is not signed by all the owners and the deed of declaration was only executed after various state deeds conveying units in thereof properties, the deed of declaration is with an intent to form an association to be registered under KOA. Section 5 reads as follows. Section 5 emphasizes that each apartment owner shall be entitled to exclusive ownership and possession of this apartment. Clause 2 of Section 5 states that each apartment owner shall execute a deed of declaration that he submits his apartment to provisions of the Act, and deed of apartment in relation to this apartment in the manner prescribed. Deed of declaration is executed by the apartment owner subjecting apartment to the provisions of the Act. This paragraph, my lords, para 14 is extracting Shantaram proposed case, which is also done earlier. Then para 15 it refers to VDP Carrington Apartment Owners Association. It said that charitable society cannot be formed for maintenance. Then para 16 it also refers to DS Max case. And the Honorable Court comes to the conclusion Honorable Court in this case comes to the conclusion that Apartment Ownership Act is the act under which society can be formed, association can be formed. This decision also may not be subject of a writ appeal. WS 732 of 25.
732
of 25. If I may state the conclusions, if one were to look at the provisions of the Act without looking at the decisions or interpretation in the first principles, on the face of it, there appears to be a contradiction between what is contemplated under RERA and what is contemplated under Apartment Ownership Act as well as Flat Act. Because why not under the Apartment Ownership Act, Section 5 Section 5 says each apartment owner should be, first of all, my lord, Section 2 of the Act specifically provides this Act applies only to the property the sole owner or all owners of which submit the same to the provisions of the Act by duly executing and registering a declaration, provided that no property shall be submitted to the provisions of the Act unless it is mainly used or proposed to be used for residential purpose. Therefore, my lord, the preliminary requirement is there must be a voluntary seeking of application of the Act by executing the declaration.
Yes.
And apartment is defined under Section 3 Clause A. Apartment means a part of property intended for any type of independent use, including one or more rooms or enclosed so in the building, intended to be used for residential purposes and is a direct exit to public street, etc. Apartment owner means person or persons owning an apartment. Owning an apartment and an undivided interest in the common areas and facilities in the percentage specified in the established in the declaration. Common areas may not be defined in clause F3 subclause F. And the first subclause in that, unless otherwise provided in the declaration, provides so. Common areas means the land on which the building is located.
Yes.
And various other things are included. Then, Section 4 provides that each apartment, together with its undivided interest in common areas and facilities, shall for all purposes constitute rentable and transferable immovable property within the meaning of any law. So, there is always a combination of building plus undivided interest in land contemplated under the Apartment Ownership Act. And of course, Section 5 and 6, etc., other corroborations. Now, under the RERA Act, Section 11 Section 11 clause 4, subclause B, which has already been referred to earlier,
Yes.
F minus. The functions and duties of promoter, clause F. The promoter shall execute a registered conveyance deed of the apartment, plot, or building as the case may be in favor of the allotee, along with the undivided proportionate title in the common areas to the association of allottees or competent authority as the case may be, as provided under section 17 of the Act. Now, section 17 reads, the promoter shall execute a registered conveyance deed in favor of the allotee along with undivided proportionate title in the common areas to the association of allottees or the competent authority as the case may be, and hand over physical possession of the plot, etc., etc. Provided that in the absence of any local law, conveyance deed in favor of the allotee or association of allottees or competent authority as the case may be, shall be carried out by the promoter within 3 months from the date of issue of OC. So, in clear distinction from what is contemplated under the Appointment Ownership Act, that undivided share and building should be conveyed to the individual allotee, RERA contemplates two different streams of individual allotee of building and association as owner. And under the Flats Act, section 10 and 11, specifically section 11, requires that promoter shall take all necessary steps to complete his title and convey to the organization of persons who take as flats, which is registered either as cooperative society or as a company as aforesaid, or to an association of flat takers, his right, title and interest in the land and building, and execute all relevant documents therefore in accordance with the agreement executed in section 4. So it contemplates that entire land and building will be conveyed to the society or company which is formed. So therefore, my lords, on a bare reading of the provisions, it would appear that there are three different types of ownership categories based on the various enactments. If one were to try to, since the Honorable Court has already held that COFA and RERA are repugnant, we will do away with the reference to COFA, my lords, only Apartment Ownership Act and RERA. So if as the Honorable Court has concluded, if RERA association can be formed pre-completion and post-completion apartment ownership association is possible, then the mode of ownership would have to change. Because Apartment Ownership Act considers only undivided interest in the allotee as the owner who can then subject for the declaration. Whereas under RERA, that is not what is contemplated. Therefore, unless the interpretation is stretched to the extent that first association of allottees has to be formed, developer or promoter has to convey the title to the association, then the association and the individual allottees can get together and determine whether association has to be formed or not. Such a interpretation of allowing both to coexist may give rise to the difficulty which is exactly being faced now. So, therefore, my lords, as far as this particular dispute is concerned, first, the basic dispute is whether that cooperative society should have been registered or not. So, the appellate authority has rejected the claim on the ground that the petitioner is not a member, he does not have any stake in the society, therefore he is not competent to challenge the registration.
Yes.
So one remedy for this is the owners association or the promoter and the society should agitate this matter in a civil suit, declare as to who is entitled to carry out this thing. Otherwise, this court will have to enter upon the issue of which is the correct association to be done. In doing so, the court can follow the decision of the coordinate bench and hold that they are not contrary. Both societies can coexist, in which case again the registration of cooperative society cannot be struck down, or follow the division bench by disagreeing with the coordinate bench and say that because of that only Apartment Ownership Act can be recognized, nothing else can be recognized.
What do you say regarding his submission that the association respondent number 5 is not an entity, it cannot sue or be sued?
That, my lords, the Supreme Court, what decision he is relying upon is also relied upon by the coordinate bench to hold that that is not an entity which can initiate any proceedings, and it is not recognized under RERA.
an update, my lord.
No,
Petition and
practically it is very difficult for maintenance and all that one association. For resolving the dispute and the issues, another association.
Akhilesh matter, stay order.
You please file your written arguments. Whatever now you have stated, whatever the suggestions. Yes. Yes.
There is a stay order there only with respect to the maintenance. Last date, my lord, the decision there. Matter came up with the one, my lord, and there are multiple matters there that we decide. And so till 30th of January, stay only with respect to the maintenance, with respect to the petitioner's subject matter, subject property.
So that is pending before the division bench.
Division. This is a petition and the appeal has been filed belatedly, where originally the petitions were 59. When they filed the appeal, only 8 or 9% are there.
Naturally, that is regarding Akhilesh Anand.
Akhilesh Anand. And also, my lord, the division bench judgment which we are referring to is also under a review. And sequence wise, one important thing is when the petitioner approached this honorable court challenging my registration is only when I filed the case before the rate.
Now construction of the building is over. Registration of the sale deed in respect of.
Within the process, not everyone is complete.
Of course, 100%
Before that,
is not.
I had a problem. I have a serious problem entering into this registered sale. In the sale deeds, my lord, and in the agreement, admittedly, they do not follow a format which is being notified under section 8A. RERA contemplates that there should be a notified format of sale deeds. And the Honorable Supreme Court has taken up it very seriously and told that pan India there should be a same agreement of sale. So that has been completely given a go by. There it requires, my lord, all the agreements to be registered, not even one agreement, not even one builder, my lord. Before the RERA, they don't register. So, my lord, I am representing one association where the builder had only 40 apartments to be sold. He has sold 86. Because all this happens because registration is not. So, again, in this case, my specific agitation, particularly the party person who had appeared before, they register a sale deed without showing the actual consideration. They show that only towards the land, my lord, I have purchased at 2 crore 36 lakhs to 67 to 3 crore. My sale deed shows only a value of 69 lakhs 70 lakhs. And say the balance has been paid by as per the agreement of sale, which is unregistered. So practically, my sale deed do not carry the consideration. And this is particularly, again, my lord, is a total fraud way. They have to evade the stamp duty and other things. So, my lord, my disputes which I raise when I go as in collectively before the RERA, what I do before the consumer court or any competent authority has to be stopped by the petition. This is the intention. This is the mistake which RERA wanted to curtail, which has to be remedied, which has come back, bringing back the redundant provisions of the Karnataka apartment. And this is what specifically the Supreme Court has been stuck off because the same attempt was made by the West Bengal government to overcome the RERA provisions. My lord, the real estate regulation should be made for the legislators, not be regulators. It should not be just to protect their interests.
What do you say regarding is there any practical difficulty if a cooperative society is registered and taken care of the interest of the owners and the allottees, as in this case?
That would appear to be what is contemplated under the RERA Act, that there is a society, there is a association, society or a cooperative society. In fact, RERA doesn't use the word company. So it is either association, society or cooperative society which is contemplated under RERA. But the difficulty arises because as it has been observed in the methodology, the difficulty, my lords, is simply this: out of 400 allottees, who is going to decide whether it is going to be an association, whether it is going to be a society, or whether it is going to be a cooperative society is not at all addressed. Now, if majority of the allottees get together and take a decision that this is the association or this is the entity I want, then there may be no difficulty. But if one batch of allottees say I want a society, another batch says this, then the legal provisions do not provide a way in which this can be addressed. For want of better solution, it would have to be meeting is called for, proposal is put to vote, and whatever the majority of the people agree will be decided. But again, my lords, that has serious implication on property ownership rights, because this is each allottee through the society or the association owns undivided interest in the land. So merely stating that the majority will decide how it has to be decided, that may also violate the individual rights which the owners have. Therefore, that is a clear lacuna in the law, my lord. That is what is also highlighted by the coordinate bench. As an interim measure, having a society which will have a right to agitate, that can be considered. The RERA also contemplates that as long as a majority come together, they can form an association, that is considered.
The same aspect was considered by the Honorable High Court of Odisha, where the court has ordered that registration of undivided interest in the name of the individual, it is illegal, because the RERA does not contemplate for it. Central legislation says that collectively the land should be conveyed to a body corporate. Registering it in undivided interest it has been held that it is illegal. I produced that statement.
We may face practical difficulty in saying so. Overnight, every owner will not get the sale deed registered.
No, it is not, my lord. Sale deed, they need not register. That is why, my lord, the common area to be reserved, and that has to be protected, because, my lord, when
common area is to be held by whom?
My lord,
common area is to be held by?
The common area includes the land and the entire common area. So that has to be conveyed in the name of the collective of the allottees. That means all persons will jointly own it.
That will never happen. That will never happen.
It is addressed, my lord. That is addressed in RERA.
What RERA says that within 2 months that has to be done. That the timeline is under the local law. If the timeline is less than 1 or 2 months, then the state law applies. And if it is beyond 2 months,
that is why I think the coordinate bench in Akhleshana has suggested initially there should be a society. As and when there are the members come, they should be the members. Compulsorily, they should be the members.
That is the reason, my lord, that section 17 has been a detailed discussion by the standing committee, which says the reasons why there cannot be an undivided interest on individual's name, because that one person can stop the entire decision making, my lord. For example, my lord, we cannot decide only that apartment is constructed and it will remain there permanently. There is a requirement for a reconstruction, my lord. Some apartments are already ready for that. When that happens, that has happened in Mumbai, and that is the reason 17 has to be included. There, the court has to hold that deal with compliance. And if one person says again, see, my building it will go for another 20 years. Another says that it is going to fall, we have to reconstruct. One person can hold that decision. That is why the central government in its legislation brought that this should not happen. There should be a cooperative moment. The majority should decide such decisions because it is a collective event. So, to overcome the major problem, section 17 has been included, and that is why it is a specific condition in the certificate being issued. Certificate says that he will comply with section 17, which has not been done.
There is one last aspect, my lords. Section 17 says that the undivided interest should be in the common area should be conveyed to the association of allottees or the competent authority. So when the time frame is not satisfied here and the allottees are not able to come together, it appears to contemplate that the land has to be conveyed by the promoter to the competent authority. Competent authority is defined under the Act as the local authority or any authority created or established under any law.
That is still worse.
that is still worse. That puts them in even more difficulty.
That is the object of the Karnataka Apartment Ownership Act.
The worst thing is not that. I put an example. There is a area earmarked for STRR road development. The development
I may be permitted to make my reply, my lord, because I had argued only for initially, because I said that it is a short question is involved. I did not touch the repugnancy. I may be permitted, I will explain, my lord. All the questions will be answered. And let them reply to my submissions.
Allah, I thought he has already addressed the argument. If you have anything to say, you put it in writing.
If at all, when the conveyance is done with respect to only the undivided interest, the undivided interest, there is no law which says that what should be the extent of undivided interest as on date. It does not say what is. Undivided interest at the hands of the builder will become its discretion. It is not told that the FIR, the entire FIR, the land completely, the common area is not being transferred. Law does not say, they don't do that at all. And what happens is, the land will always remain, the revenue records will always remain in the hands of the owner.
Of course, but undivided interest, each owner will get proportionate.
But proportion is decided by the builder, because now law gives a clear cut statement. How much should be the undivided interest?
No, proportionate means proportion in
There
all.
are zoning regulations are there, Planning Authority Act is there, which defines, and accordingly the khata will be issued. And these are all totally incorrect, my lord. I will explain, my lord. Each interplay between all these legislation, I will explain, my lord. And the
See, if you say proportionately, you are entitled for common area. It is proportionate.
No, my lord, but
If there is any mistake in calculation, you cannot blame the law.
That is what I am before the RERA, saying that the calculation is wrong.
Calculation you can set it anytime.
That is why I told
You cannot blame the law for that.
No, my lord, but then my lord, how come they can have a restricted common area, which is not permitted under the RERA? The common area is given to everyone, and certain area is given to a private person's use. That has been done in this project.
That is not, may not be permissible.
So that is what I want to agitate. My property has been sold to someone else. Well, where is happened? When I want to agitate that, they come.
Now,
my existence is in question.
who is maintaining the project?
My lord, it should be maintained by the builder, my lord, because as per their agreement.
Practically, who is maintaining?
We are maintaining.
They formed this association and pushed it over to them to dilute the corpus fund. Again, that is my issue.
My lord, the mischief, fraud, forgery, everything I am hearing. And he says that he says that they have been compelled to execute Form B. There should be some end to that.
Yes.
My lords, the only, from my end, for the society under KOA, association under KOA, the deed of declaration was first made. The allottees have formed the cooperative society subsequent to the deed of declaration being formed after becoming owners, number one. And number two, my lords, the issue at hand that we have today is the UDS is already sold. So the question of now giving any direction to the association of allottees under section 17 may open a Pandora's box, because
no, he is raising so many issues. Some are very serious. Who has to address that?
My lords, RERA.
Whether you have taken up that issue with
No,
the
my lords,
appropriate
we are maintaining the association.
You are maintaining is
Please, my
entirely
lords.
different. See, individual owner may have some issues.
Please, my lords, they can approach RERA.
Events.
Please.
Who has to address that?
Please, my lords.
Individually, they cannot go and agitate again, fight against the promoter. Or
No,
the
my lords are
builder.
absolutely right.
Correct.
Which is why RERA gives them that option. Nobody is saying, that's why we are not saying that they can't exist as a cooperative society.
You join hand with the respondent number 3.
Because they represent.
My lord, because I think some of the owners or most of the owners who are part of this association may have not faced that kind of grievance. It appears to be very specific to some allottees.
Cannot have faced that. But there are some owners.
I'm not disputing
allottees.
that. Absolutely.
What should happen to them?
My lords, they can go before RERA. I am not against that at all.
You cannot say, no, I have not faced anything. So
No, no.
I am
No,
saying-
no, my lords. That's not the case.
323
That's not the case, my
apartment
lord. So
owners
far
have
as
no
I am
issue.
concerned, the owners, anybody in the association, nobody has come to the association with these kind of queries, number one. Because if these queries are brought by the members, then the association can consider. Now, number two, the only issue that we are.
Even if it is to be brought to your notice, as already held by the apex court, the association is not registered. It is only an association of individuals.
It's created under the statute. Please,
Of
ma'am.
course.
And we can maintain the association. There's no difficulty there. I understand there is some kind of issue so far as.
Not the only issue, ma'am. There are
Yes.
more serious issues.
And in fact, even in Akhilesh Anand, there is a paragraph where the coordinate bench very clearly says that in case of any issues so far as structural defects are concerned,
KOA who's maintaining, because that arises post ownership, because you will only find out uh, structural defects post ownership. So there is a paragraph which says KOA can also consider going to RERA. So it's not as if we can't take action. But to me, it appears, based on submissions of the learned respondent number 3, it appears that
Owners have not approached you or highlighted their issues with you.
my lord,
With
so
the
far as the society is the present respondent number 5 is concerned, none of the office bearers or members have come up with any grievance, because we've also taken a handover from the.
They are also members in our association.
Please, my lords, they are. They have not brought forward because they are
What may
agitating.
be the reason?
They have no issue.
My lords, they are
That is-
agitating under a different association.
No, my lord, that is the fact.
Some of the members in respondent number 3 association
Yes, ma'am.
are having some issues.
They are having the issue, but they are so minority. Those issues are not being considered by the other members because it is not an issue at all. And that is the reason why, my lord, we are before my lords.
No,
No. Let me. I may be permitted to make my submission. Yes, my lord.
Right.
My lord. First thing is that, my lord, why this Karnataka Apartment Ownership Act?
No, you also and learned counsel respondent number 3. You also, if you want, you can file your written arguments.
Please, my lords, we'll file.
Yes.
Lord, why this Apartment
But
Ownership
let it
Act?
be very brief.
Very brief.
Don't make it very long. Yes, yes.
Lord, the question is that, my lord, why this Apartment Ownership Act was enacted in the year 1972? What was the regime earlier to 1972 is one question, my lord. The second question is whether the association formed under the Apartment Ownership Act, what is the status of that particular Apartment Ownership Act is the another question, my lord. Now, whether this Apartment Ownership Act operates in a particular field and whether it is repugnant to that of the RERA Act is another question, my lord. My lord, to understand these aspects, my lord, we need to understand which is the first legislation with respect of these type of properties. The 1882, the Transfer of Property Act is the first legislation. The Transfer of Property Act, though it dealt with the predominantly the land, my lord, it was not dealing with the multi-storied vertical complexes, multi-storied building. So for that reason, my lord, there was a lot of difficulties. My lord, what happened in Maharashtra? I will just give the background, my lord, because to understand this particular legislation, more particularly Apartment Ownership Act and similar type of legislation is available in Maharashtra and other places. What happened in the year 1950, my lord? The Cooperative Act was legislated in Maharashtra, my lord. Then, since the multi-storied building concept was not recognized or well appreciated under the Transfer of Property Act, the housing cooperative societies were formed in the year 1950. But these housing cooperative society would have the property in their name and one particular share will be given to the owner. And that particular share will not be registered with the sub-registrar. That was the difficulty. And there was an intervention of the authorities. For that reason, my lord, the Maharashtra is the pioneer state which legislated in the year 1970. That is the Maharashtra Apartment Ownership Act. That is the first legislation. My learned friend said that there is an amendment to that particular legislation in the year 2023 post-RERA. The redevelopment concept was not available in the Apartment Ownership, Maharashtra Apartment Ownership Act. For that reason, redevelopment has been introduced in the year 2023 after RERA. In the Apartment Ownership Act, first time, my lord, they defined what is the common area, what is the association, how the association has to be formed, what is the deed of declaration, how the property has to be transferred and all those things. The reason was that, my lord, the encumbrances was the issue, how the property has to be encumbered, how the property name has to be registered with respect of common area, all those the questions. So for that reason, my lord, Maharashtra Apartment Ownership Act was legislated. Similarly, we followed the suit of Maharashtra Apartment Ownership Act. In the year 1972, Karnataka Apartment Ownership Act was legislated. The Karnataka Apartment Ownership Act is only for the residential project. It is not with respect of the commercial project. Insofar as the commercial project is concerned, Karnataka Flat Ownership Act is legislated, my lord. There, my lord, the office unit, commercial unit has been contemplated. Deliberately, my lord, in the Karnataka Apartment Ownership Act, it is restricted to the only residential. The reason is that they don't want to introduce the commercial. If the commercial is introduced, my lord, then the cooperative society is possible. Because there should be an element of commerce. If it is a company, my lord, then it is possible if the company has to be registered. For that reason, my lord, the legislator in Karnataka, in its wisdom, restricted only to the residential project so that there should not be any interference, and that particular body should be an association of the residential apartment owners, and it should be minimal interference by the authorities. So there is no audit, there is no superseding, there is no intervention, there is no politics, there is no election in these type of association. That is for grace, my lord. Fortunately, my lord, these are all away from the politics. After 1972, my lord, the question was pre-ownership. The Apartment Ownership Act only addresses the post-ownership. What is the issue regarding the pre-ownership? There was no legislation. In that context, my lord, the Maharashtra legislated one particular act in the year 2012 itself, that is Maharashtra Housing Regulation and Development Act. That is actually it is a RERA Act itself insofar as Maharashtra is concerned in the year 2012. That particular legislation has been taken into consideration. Even the draft committee also considers that particular aspect. And for Pan-India, RERA Act was legislated.
Yes.
The Pan-India RERA Act legislated for the pre-ownership, and it also has addressed certain issues with respect of post-ownership. But those are with respect of defect liability period, but not with respect of post-ownership and maintenance. The concept of maintenance, concept of managing the property, RERA is completely silent. It is the Apartment Ownership Act alone deals with that issue. Then, my lord, RERA Act was legislated. When the RERA Act was legislated, expressly that particular legislation, the Maharashtra's legislation, which is similar to that of the RERA Act. I request my lords to kindly take section 92 that deals with the repealing of the legislations. Section 92 of the RERA.
Yes.
The repeal, my lord. The Maharashtra Housing Regulation and Development Act 2012 is hereby repealed. They repealed this particular legislation. The reason is that, my lord, it is similar to that of the RERA. They did not repeal 1970 Act of the Maharashtra Apartment Ownership Act. The question of repealing does not arise at all. The reason is that it operates in a specialized field. Now, my lord, what happened? This particular legislation was legislated in the year 2016. In two trenches, it was legislated. It was given effect. Then, my lord, the West Bengal wanted to give effect to this particular legislation, and they prepared a draft rules also under this particular legislation. But at the end moment, they did not go with this particular legislation. On the contrary, they copied the entire legislation. The same RERA legislation was copied, and West Bengal HERA Act was legislated in the year 2017. Sorry, bill was introduced. Bill was passed, and it was sent for the signature, sent for the consent of the governor. At that particular stage, my lord, there was a challenge. The challenge was that this particular West Bengal HERA Act is complete copy paste of the RERA Act. Whether there could be two legislation was the issue.
Yes.
Then that particular question was considered by the Supreme Court. The Supreme Court has considered the repugnancy between these two legislation, and while considering the repugnancy, the court has completely considered all the provisions of the RERA compared with that of the West Bengal HERA Act, and the Supreme Court has come to a conclusion that this is copy and paste. And the court has come to a conclusion in the teeth of Article 254 that this is repugnant legislation, and accordingly struck down this particular legislation. Now I want to pose a question to myself, whether that particular judgment, whether those observations with reference to that particular act can be made applicable to in our case. No. Now, my lord, the next question is that, my lord, there are special laws with respect of each of the state. In Orissa, there is a special law with respect of the common areas.
Yes.
In Kerala, there is a special law. Karnataka, there is a special law. In some of the state, there are no special laws at all. That is the reason why in so many places in the RERA,
In the absence of the special law, in the absence of local law, what should happen has been explained. In such an event, if there is a special law is available in your state, that particular special law has to be made applicable, and also that particular provision has to be given effect to. My submission is that, my lord, if we need to understand the object of the 1972 Act, how that particular legislation has been legislated, from the 1972, my lord, thousands of associations have been formed, registered, and it is functional. If these associations are now said that no, because of RERA, your association is not in existence, my lord, all those associations will become defunct.
Yes.
My lord, Supreme Court in People's Foundation case, while considering the repugnancy in the light of Article 254, they have considered from the Javeri Bai versus State of Bombay, that is 1955 first judgment with respect of the repugnancy, my lord. And till this point of time, that is Yam Karunanidhi judgment has been considered, and the Supreme Court has considered the three tests which has been laid down in the Javeri Bai judgment, then Yam Karunanidhi judgment, and thereafter those three tests have been applied with respect of that case. Now my submission is that they are relying upon that judgment. Even the coordinate bench has referred to that judgment. My submission is that in the light of those three tests, these Karnataka Apartment Ownership Act and RERA has to be considered. I request my lords to kindly take the Supreme Court judgment, that is with regard to Forum for People's Collective Efforts, my lord. That is 2021 8 SEC 599. Madam, ಸ್ವಲ್ಪ ಕೊಡ್ತೀರಾ ಈ ರೀತಿ ಇದೆ ನೋಡಿ. Forum for People's Collective Efforts.
You have given it separately?
Yes, my lord, it has been given separately, my lord. Hope my lords has the judgment.
Yes.
I request my lords to kindly take page number 618, my lord. There is an index. Serial number 8, my lord. What is the challenge? It has been explained, my lord. I will read it, my lord. Only there are two paragraphs are there. Then, my lord, serial number H, my lord, the analysis. In that analysis, my lord, H2 is with respect of constitutional scheme of Article 254 and repugnancy. Then repugnancy between RERA and West Bengal HERA Act. Then, my lord, meaning, addition, and all those things. And the lack of presidential assent. The president has not given the assent, and the conclusion has been given. Only these portion I will refer to, my lord. I will try to make the submission. With respect of in the same page, my lord, what is the challenge? The challenge, it reads like this, my lord. The constitutional validity of West Bengal House Industry Regulation Act 2017 is challenged in a petition under Article 32. The basis of the challenge is that both West Bengal HERA and parliamentary enactment, the RERA, are relatable to the legislative subjects contained in entries 6 and 7 of the concurrent list of the 7th schedule of the Constitution. West Bengal HERA has neither been reserved for nor it has been received the president assent under Article 254(2). The state enactment contains certain provisions which are either directly inconsistent with the corresponding provisions of Central Act or a virtual replica of the Central enactment. So it falls under the second category, that is virtual replica of the Central enactment. The Parliament having legislated on a field covered by the concurrent list, it is constitutionally impermissible for the state legislator to enact a law over the subject matter by setting up a parallel legislation. So the court has come to a conclusion that it is a parallel legislation. No, my lord. B, legislative history.
Yes.
Before Parliament enacted RERA in 2016, the state legislature had enacted several laws to regulate the relationship between the promoter and purchasers of real estate. Among them was West Bengal Building Regulation of Promotion of Construction and Transfer by Promoters Act 1993. My lord, we are not dealing with this particular legislation, my lord. We are dealing with the 2017 legislation, my lord. 1993 legislation is a different legislation. This legislation of the state of West Bengal was reserved for and received presidential assent, following which it was published in the official gazette on 9/3/1994. Many other states enacted laws on the subject, including among them the Maharashtra Housing Regulation and Development Act 2012, which received presidential assent on 2/2/2014. The Kerala Real Estate Regulation and Development Act 2015 was enacted by the State Legislative Assembly on 3/2/2016. My lord, category 1, that is Maharashtra, which is expressly repealed, which I have read. The Kerala, there is no express repeal, but there is an implied repeal. Para number 4, my lord.
Yes.
On 14th August 2013, the bill for enactment of RERA was introduced in the Rajya Sabha. The bill was passed by the Rajya Sabha on 10th March 2016 and by the Lok Sabha on 15th March 2016. The law received the assent of the President on 25th March 2016 and was published in the official gazette on next day. RERA was then partially enforced on 1st May 2016, while the rest of its provisions were enforced on 19th April 2017. The Maharashtra Act was specifically repealed by the RERA, while the Kerala Act was repealed by the State Legislative Assembly through the Kerala RERA Estate Repeal Act 2017. Next, my lord, this is the facts of this particular case, my lord, that is decided by the Supreme Court. In the state of West Bengal, draft rules under RERA were framed on 18th August 2016, but no further progress was made in that regard. On 16th August 2017, the motion for passing the West Bengal HERA bill was adopted in the State Legislative Assembly. My lord, the date would assume a lot of importance, my lord. That is on 16th August 2017, after the legislation of RERA. The state enactment received the assent of the Governor of West Bengal on 17th October 2017. Inter alia, the West Bengal HERA repealed the West Bengal 1993. The remaining provisions of West Bengal HERA were enforced by a notification dated so and so, issued by the Governor of West Bengal in exercise of the power conferred by subsection 3 of section 1 of HERA. Thereafter, on 8/6/2018, the state of West Bengal framed rules under West Bengal HERA Act. Then this particular legislation was challenged. Now I request my lords to kindly take how the court has analyzed. I request my lords to kindly take page number 704. The analysis starts at para number H, my lord, after para number 100. At left side, my lords would get, that is list 2 entry 24, West Bengal's housing industry defense. I will not read those paragraphs, my lord. I request my lords to kindly take page number 709, where the court refers to the constitutional scheme of the Article 254 and repugnancy. H2 from 113 would become relevant, my lord. In fact, in Arun Kumar judgment, these particular paragraphs have been taken into account. Para H2, my lord, page number 709.
Yes.
There, my lord, the part 11 of the Constitution, then Article 246 legislative competence and all those things have been taken into consideration. At page number 711, my lord, Article 254 has been referred to, that is with reference to repugnancy, my lord. Then the discussion with respect of Javerbai Amainda's case starts at para number 118, page number 713. Para 118, my lord. That is the first decision with respect of a repugnancy is concerned in the teeth of Article 254, my lord. The 3 tests, though not called out, that was first evolved in this particular judgment, my lord. Thereafter, my lord, in Tika Ramji's judgment, my lord, that my lords would find at para number 119, my lord. Then the next judgment, the same judgment, my lord, the reference is with respect of the Australian Constitution with regard to section 109, which is similar to that of article 254. Then I request my lords to kindly take para number 121, where once again the Supreme Court has considered the repugnancy doctrine, my lord. Then the next judgment which would be relevant for this particular case is at page number 123, my lord. Page number, 716, my lord, para 123. Here, my lord, the Javer Bhai, Tika Ramji and Deep Chand, all these legislations have been taken into consideration and the 3 tests have been culled out at page number 717, my lord.
Yes.
Repugnancy between 2 statutes may thus be ascertained on the basis of following 3 principles. Whether there is a direct conflict between the 2 provisions. 2. Whether the Parliament intended to lay down an exhaustive code in respect of the subject matter, replacing the act of the state legislature, whether it is an exhaustive code. The 3rd test in respect of this particular case. Whether the law made by the Parliament and law made by the state legislature occupy the same field. Lord, they have italicized this particular para 3, my lord. Point number 3, my lord. The reason is that, my lord, it specifically falls under that particular category. Lord, I want to pose a question to myself. Whether the Karnataka Apartment Ownership Act as well as that of the RERA would fall under any of these category. It won't fall under any of these category. And that has been already held by the coordinate bench as well as the division bench, that there is no repugnancy. Then, my lord, after discussing all these judgments, my lord, the Karnanidhi judgment has been considered at page number 718, para 125, my lord. Once again, they have culled out. Those 3 principles have been further elaborated in Karnanidhi judgment, my lord, that has been expanded in para 125. It has been culled out in this particular para 125, my lord. I will not read it, my lord. Then, my lord, after analyzing all these provisions, all these judgments, then, my lord, at page number 726, page number 726, under the head of repugnancy, RERA and HERA Act, the discussion starts. Page number 726, my lord, para 134.
Yes.
There, my lord, they have considered the various definition, that is commencement certificate, competent authority, sanction plan, planning area, and then occupancy certificate, local authority. All those things have been taken into consideration. After taking into consideration all these aspects, my lord, then under the head at para 174, page number 743, knitting it together at para 174, the court has given its final verdict, my lord.
Yes.
From our analysis of provisions of RERA on the one hand and West Bengal HERA on the other, 2 fundamental features emerge from a comparison of the statute. First, a significant and even overwhelmingly large part of HERA overlaps with the provisions of RERA. These provisions of the RERA have been lifted bodily, word for word, and enacted into the state enactment. Second, in doing so, West Bengal HERA does not complement RERA by enacting provisions which may be regarded as in addition to or fortifying the rights, obligation, and remedies created by the central enactment. The subject of the provisions of the state enactment is identical. The content is identical. In essence and substance, West Bengal HERA has enacted the parallel mechanism and parallel regime as that which has been entailed under RERA. The state legislature has, in other words, enacted the legislation on the same subject matter as the central government enactment. By observing these things, my lord, the Supreme Court has struck down. My lord, in the light of this particular facts and circumstances, more in the light of the RERA Act and West Bengal Act, whether the Karnataka Apartment Ownership Act can be considered as repugnant. Now I request my lords to kindly take the Karnataka Apartment Ownership Act. My lord, the object of this particular legislation, I request my lords to kindly keep the object of the RERA side by side, then it would become easier. Whether this object has been incorporated in the object of the RERA is the question I want to pose myself. I want to read the object of Karnataka Apartment Ownership Act first, my lord. Hope my lords has the Karnataka Apartment Ownership Act object, my lord.
Yes.
An act to provide for the ownership of an individual apartment in a building and to make such apartment heritable and transferable property and for matters connected therewith. My lord, initially when I started my submission, my lord, the Transfer of Property Act, though deals with the immovable property, it won't address the vertical growth of the urban area. The vertical growth of the urban area is required to be addressed. For that reason, Karnataka Apartment Ownership Act deals with that. It says that the apartment heritable and transferable, was required to make it heritable and transferable. Because if a housing society is registered under the Karnataka Cooperative Society Act, share will be there, share will be transferred, but apartment will not be heritable and transferable. And that is contrary to the very concept of the Transfer of Property Act. And with that object, this Apartment Ownership Act and all other states also followed this legislation. Next, my lord, whereas it is expedient to provide for the ownership of an individual apartment in a building and to make such apartment heritable and transferable property and to provide for matters connected therewith. Then, my lord, I request my lords to kindly take section 26.
Yes.
It refers to the Transfer of Property Act. For the removal of doubt, it is hereby declared that the provisions of Transfer of Property Act shall, insofar as they are not inconsistent with the provisions of this act, apply to every apartment, together its undivided interest in the common areas and facilities appertinent to the such apartment, as those provisions apply in relation to any immovable property, and the provisions of this act shall take effect notwithstanding anything to the contrary contained in any contract. And my submission is that, my lord, the Transfer of Property Act, insofar as immovable property is concerned, apartment is concerned, is applicable. But insofar as any other areas which is specifically covered in this act, it is specifically applicable. For example, my lord, if this particular legislation is considered as repugnant, then entire, my lord, the whatever the registration which has been done, which is being followed in the state of Karnataka, it will come to a standstill. Now kindly take, my lord, what are the provisions which is available in this legislation, my lord. The first one is that, my lord, with respect of this legislation is, my lord, section 2, which the amicus has read, my lord, it is applicable to only residential purpose. I will not read it, my lord. Then there is one particular provision, my lord, that is common areas and facilities, which my lords would find in RERA also, however with a different object. The definition 3F is common areas and facilities. Same, my lord, what we have defined, the same thing has been defined in RERA also. Then there is one definition, my lord, common expenses. This definition is not available in RERA. What is common expenses? What is common profit? Those things have been defined in this particular legislation. Then, my lord, who is the competent authority? That also has been defined. Then, my lord, section 4 is the important provision, my lord. Section 4, 5, 6 are the very important provision, my lord. Section 4 declares what is the status of apartments, because the apartment should be made heritable and transferable. So for that reason, this declaration of law has been made regarding the status of apartment. Each apartment, together with its undivided interest in common areas and facility appertaining to such apartment, shall for all purposes constitute heritable and transferable immovable property within the meaning of any law for the time being in force in the state. Lord, this particular status of apartment is not available in Transfer of Property Act. This particular status of apartment is also not available in RERA Act. And this is specifically incorporated. Now, section 5, my lord. Ownership of apartments. Each apartment owner shall be entitled to the exclusive ownership and possession of his apartment. Each apartment owner shall execute a deed of declaration that he submits his apartment to the provisions of this act and deed of apartment in relation to his apartment in the manner prescribed for the purpose. My lord, in the year 1972, we have gone one step ahead and we have provided the formats. Bylaws have been provided. And as per that particular bylaws, my lord, we have deed of declaration has been executed. Everyone is supposed to submit the form. And accordingly, my lord, though it is a unique it may be unique for others, for the pan India, we have a separate scheme. And as per that particular separate scheme, my lord, common area has been defined. The undivided interest has been defined. Apartments have been defined. Parallelly, my lord, with respect to these legislation, my lord, the khata, how it has to be issued. Individual apartment khata, how it has to be issued. How the khata with respect of the entire property has to be issued. How the khata with respect of clubhouse has to be issued. All those things have been explained in zoning regulation. Accordingly, it has been done.
Yes.
Now I request my lords to kindly take section 8, my lord, which prohibits certain work by the any individual apartment owner, which affects the safety of the property. No work cannot be carried out. That is the declaration which has been made under section 8. Then my lord, section 9, with reference to the encumbrances against the apartment, how the encumbrance has to be created with reference to the apartment with respect to the common area. Then my lord, again there is a reference to the Transfer of Property Act under section 9. I will not just read it, my lord. Then my lord, section 10, my lord, which deals with the common profits and expenses, how it has to be distributed among and how it has to be utilized, that has been explained. Then my lord, section 11, it deals with the contents of declaration. Then my lord, section 13, the contents of declaration is available in section 12, my lord. What should be the content and all those things. Then section 13, declaration, deed of apartment and copy of the floor plans to be registered. So the registration, how it has to be done, what should be accompanied with the deed of declaration, all those things have been explained, my lord. Then registrar has to register it. Then my lord, I request my lords to kindly take section 20. Section 19, which deals with the charge on property for common expenses, how the charge has to be created. Then section 20, joint and several liability of vendor for unpaid uncommon expenses. Then section 22, disposition of property, destruction or damage, then how it has to be dealt with. Redevelopment has not been incorporated in our legislation, but Maharashtra has incorporated it, my lord. Then section 25. Section 25 empowers the formation of the rules by the government, my lord. Those rules are formed in the year 1974. Those rules are also available, my lord. And these rules provides Form B, Form C, Form D, Form E. And accordingly, it has to be executed.
Yes.
No, my lord, I request my lords to kindly take the RERA Act, my lord.
Yes.
Yes, ma'am. Kindly take the object of this legislation, my lord. I will not take my lords through the provision and all those things. Kindly look into the provision of the object of this legislation. An act to establish real estate regulatory authority for regulation and promotion of real estate sector and to ensure sale of plot, apartment of building, as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear the appeals from the decision, direction or orders of the real estate regulatory authority and adjudicating officer, and for the matters connected therewith or incidental thereto. The object of RERA is compared to that of the object of the Karnataka Apartment Ownership Act. It is totally different.
Yes.
Now kindly take, my lord, the chapter wise. I will not read it, my lord. Chapter wise, preliminary, chapter number 1, preliminary, my lord. Chapter 2, registration of real estate project. That is sections 3 to 10, my lord. I will not trouble my lords by reading. Chapter number 3, my lord, functions and duties of promoter. Then, my lord, chapter number 4, rights and duties of allottees. Then, my lord, chapter number 5, the real estate regulatory authority. Chapter number 6, central advisory council. Chapter number 7, the real estate appellate tribunal. Chapter number 8, offences penalty adjudication. Chapter number 9, finance account audits and reports, that is with reference to the grant of the central government and state government and constitution of a fund. Then miscellaneous. None of these provisions deal with heritability of an apartment in Karnataka and transferability, common expenses, common profit, utilization of that fund.
Yes.
If these two legislations are compared with the 3 test which is evolved in Javeri Bhai's case, subsequent to the Javeri Bhai case, which has been further reiterated by the Supreme Court in People's Foundation case, my lord, this legislation operates in a specialized field and RERA operates in a different field.
Yes.
Therefore, there is no repugnancy, my lord. Now, the next question is, if there is no repugnancy, whether the association can be formed. My learned friend who is supporting me, she made a submission that it is a statute registration. It is a statute-backed registration.
How much time you may require?
I need some more time, my lord, because I have to explain. Tomorrow also I will continue, my lord, if my lords permit.
Tomorrow ಮಾಡಲಿ sir. Connectivity, continuity over.
Because your lordship, my specific intentions are regarding the overlapping and how it comes in the way of enforcement. Adana, I have to be given an opportunity.
Let him complete, sir.
Then maybe tomorrow
let
will
him,
be here.
let him complete.
I'm hoping my lord on 17th.
No, that on your behalf, somebody should make a representation. No, it is corrected here. Huh? Oh, that is correct. This to refer. Tomorrow. Heard, yes.
Serial number 10 to 15 Arjun. Serial number 16 P. Rudrappa.
My lord, serial number 11 is concerned, my lord. It is, my lord, pertaining to Society Registration Act, my lord.
11.
11, my lord.
I'm for a petition in that case, my lord. Some urgency, tomorrow it may be listed after, the office may be directed list is tomorrow.
The Society Registration.
Society Registration Act.
Tomorrow
Tomorrow it can be.
it is noticed that the petition is under Society's Registration Act.
Society registration 1960.
Hence, office is directed to list the matter before appropriate bench. Then counsel for the petitioner submits that there is urgency in the matter. Office is directed to take note of the same. Yes.
Tomorrow.
ನಾನ್ ಡೇಟ್ ಕೊಡಲ್ಲ ಸರ್.
ಅಲ್ಲ ಯಾಕೆಂದ್ರೆ
ಆಫೀಸಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡಿದೆ. I have recorded your submission.
ಅಲ್ಲ it may be tomorrow ಅನ್ಸ
ಸರ್ ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ನಾನು ಡೇಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ? It is not.
Move this matter, but court number 12 ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿದ್ವಿ, ಅದೇನೋ ರಾಂಗ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಸರ್ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಸಬ್ಮಿಷನ್ ಅನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ, ರಿಜಿಸ್ಟ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ.
Yes.
Yes. Yes.
Serial number 16, my lord, election already held on, my lord, 23/7/25. Interim orders, my lord, 22/7/25, my lord. Lordship already passed an order to regard, announce the results.
Petition. When it counsel for the petitioner is absent, no representation. Then at AGA for respondent, which respondent?
1, my lord, 1 and 3, 1, 3 and 4.
1, 3 and 4. Submit. That the election is already held on
23/7/25, my lord. Their interim order is there also.
2025.
Interim order, my lord, 22/7.
Pursuant to the interim order dated 22/7/2025. Petitioners will cast their vote, and accordingly they have cast their vote. ಎಲ್ಲಿಗೆ ಹಾಕ್ಬೇಕು ಅವರು? Which is the alternative?
Regarding, my lord, the over 70, section 70, please.
The petition, in view of the same, the petitioners have to raise a dispute
Please.
under section 70 of CCS Act. Hence place for disposal of the petition.
The
This tomorrow.
vote should not be counted, my lord. Vote shall not be counted, my lord, that.
ನಾಳೆ ನೋಡೋಣ, ನಾಳೆ ಒಂದು ಡೇಟ್ ಕೊಡೋಣ.
Please, please.
ಎಲ್ಲ ಅಜ್ಜನ್ ಅಂತ ಹೇಳಿದ್ರಿ ಮತ್ತೆ ಮಾಡಿದ್ರಿ ಅಂತ.
17 also, my lord.
ಅದು ನಾಳೆಗಿರಿ. Yes.
17 also, my lord, election held on 27/7/25, my lord. Interim order, my lord, 24/7/20.
Interim order
24/7/25. 18 also, my lord, election on, my lord, 7/9/25.
ಬಸವರಾಜ್.
Interim order, my lord, 28/8/25.
ಸರಿನಾ? Yes.
And 19, my lord, 19, my lord.
In this case,
19.
similar matter is disposed of.
ಆಯ್ತು. Has filed a memo. ಅದ್ರಲ್ಲಿ ಏನಿದೆ ನೋಡ್ಕೊಂಡು. Yes.
Serial number 20.
21, my lord, it is this. 21, my lord, it is in infructious, my lord, 17/12 election, my lord. The interim order is not passed by this honorable court.
In fact, filing memo. Withdrawal. Yes, counsel for the petitioner filed a memo seeking permission to withdraw the petition as the same is rendered infructuous. Yes.
Serial number 22. E. Chandrasekharaya, Mudukar Deshpande.
This is the case where the settlement has been arrived. Which has been, as expected, the first step got bounced.
It is not yet bounced. As per my instruction, the client has requested the bank. Bank people has given a time to 10 days since his wife is hospitalized and she is in ICU.
Virtually it is dishonored. You may give 100 reasons, but legally it is dishonored. Next. First, then the counsel for respondent submits that the first check for ₹40 lakhs issued by the petitioner dated 3/12/2025 is already dishonored. Dishonored. ಏನು reason ಏನು ಗೊತ್ತಿಲ್ಲ. Dishonored, and therefore the settlement is not effected. Then a counsel for the petitioner and respondent submit that they will address the arguments on merits. next date of hearing, this time. On merits, you address the argument. Yes.
Serial number 23, B.K. Manjunath, B. Prabhakar.
Some side argument I
This morning I sought for the
Government
time.
ನಿಮ್ದಾಗಿದೆ.
House.
I need an instruction regarding, my lordship, there is society is not in existence, my lordship. 1994, the resolution was passed regarding there is no existence of society. Liquidation agogide already. That is commit, society ಯಾಕೆ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ liquidation agogide 94 ಅಲ್ಲೇ. That committee has been formed, my lordship. Regarding those committee, we are finding out what is happened in the committee and it may be listed of.
ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ರಿ? ಸೊಸೈಟಿ
Society Karnataka State Road Transport Corporation.
which is went to liquidation now.
In 1994.
ಯಾವುದು?
Karnataka respondent 4.
It went into liquidation.
Please.
ಯಾವಾಗ?
Well, that's what, ಅದು committee ಮುಂದೆ ಇತ್ತು. That is for, to secure some records. I need a time, my lordship. Those records I'm finding out.
Try this one.
Mallards, first we have engaged the senior counsel, Mallards. Any date except for 17th, any date may be granted, Mallards.
17th ಆದ್ರೆ ಮತ್ತೆ January.
After vacation. my
No,
lordship.
Mallards, except for 17th, any day before or after any day.
Release from that. Come, take BDS. Pay for time. Respondents pay for time. ಬೇಕಂದ್ರೆ ಹಾಕೊಳ್ಳಿ ಅವರು so convent. Submit that respondent number 4 is already went into liquidation. And please for time to get further details in the matter. Yes. Next.
Serial number 16, P. Rudrappa.
Not the
Result has been announced, my lord.
ಯಾವ್ದು?
Infructuous, my lord. 16 and 17.
16, my lord.
16
Now,
and
my lord.
17.
16 and 17, my lord.
ಅದು ನಾಳೆಗೆ ನೋಡ್ತೀವಲ್ಲ ಅದು. ಏನಾಗಿದೆ? Result not yet declared.
Result declared, my lord.
Declared, my lord.
In both the cases, my lord.
Interim
16
order.
and 17.
Pursuant to the interim order.
Please.
Permitted to vote and the result is already declared.
Please, my lord.
Nothing remains. ಏನಾದ್ರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇದೆಯಾ 17 ಅಲ್ಲಿ?
My lord, 16 and 17, both, my lord.
ಅಲ್ಲ under section 17 a dispute is to be raised.
ಇಲ್ಲ, dispute ಇಲ್ಲ.
ಏನಿಲ್ಲ, ಅದೇನು ಬೇಕು. You are filing a memo?
Please, my lord.
Counsel for the petition.
As over matter, list 1, serial number 1, Pradeep Kumar K.M.
Not compliant. Counsel for the petitioner is absent, no representation. Office objections. Not complied with. ಯಾವುದು? List number 2. Counsel for the petitioner is absent, no representation, even when the matter is passed over twice and again called. The order sheet dated also reads as under. Right of said there is no complaints of this objection. Petitioner is not interested in dismissed. These two matters, so some other day. ಹೌದೌದು.
List 2, serial number 1 to 10.
My lord, serial number 1 also, my lord, election matter, my lord.
Serial number 1, this I am appearing for petitioner. In this case, my lordship, that all the petitioner, that elections is over and results also announced.
Also, my
Then
lord,
lord's body is also-
benefit of the interim order, my lord, that there's a vote has been counted and my lord, office.
Memo, sir. File a memo.
Yes.
File a memo.
Hello, what has happened? This Samra court has directed the 4th respondent to conduct the inquiry with regard to these 1 to 78 members are eligible or ineligible voter. So they, my lord, that DRCS 4th respondent conducted the inquiry, then submitted the report saying that all the petitioners are eligible
I think
members.
you can make use of that.
Yes, it could be disposed, my lord.
File a memo.
I'll file it.
Lord, regarding.
Lordship,
The petitioner file.
serial number 6.
Report also submitted, my lordship.
ಇದ್ರೆ
Yes, yes.
Connected.
Connected, my lord.
Yes, I am.
Name at the
First one arrow.
Amrit Chaudhary.
Amrit Chaudhary, my lord, different matter, my lord. Different council.
1.1 council, learned council for the petitioner. filed a
But
memo.
pertaining to same election is concerned.
Same elections. They have filed an impeding application.
ಅದರಲ್ಲಿ ಒನ್ ಅಲ್ಲಿ learned AGA make submission, same submission ತಗೊಳ್ಳಿ. You file a memo.
I'll file a memo.
Taken ಅಂತ ತಗೊಳ್ಳಿರಿ. Same submission, learned AGA make submission ಅಂತ ತಗೊಳ್ಳಿ. Dispose of. Next. ಎರಡು ಬೇಡ. Next.
My lord.
Lordship,
Serial
serial number
6, my lord.
6, I am a impleading applicant. The same connected
Election
society
election
was dismissed by your lordship.
I
and
may be
punished.
permitted to make submission. He is an impleading applicant, he should to stick.
Sir, ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸರ್. ಎರಡು serial number 2.
2.
225, my lord, same matter, my lord, KPID matter, my lord, that day, my lord, they argue.
ಅದೆಲ್ಲ application.
Speak, my lord, it can be disclosed, and covered is in my son. I have that.
Then
6,
I am appealing for the petition.
Lordship has dismissed the same
My
society
submission is
petition.
that impeding applicant should be confined to his own submission, not my submission. I am making my submission before the Honorable Court, but he is interpreting my submission.
ಸರ್ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಏನು ಅಂತ ಹೇಳಿ. ಸುಮ್ಮನೆ ನಿಮ್ದು ಏನೋ ಒಂದು ಇಲ್ಲಿ ಕೈ ಹೇಳೋದು ಬೇಡ.
I have been permitted to cast my vote in the election held on 25/10/2000.
You have already cast your vote.
Yes, your lord.
Then what remains?
It may be disposed of as.
ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದಲ್ವಾ?
I being a petitioner, I should submit. He is an impleading applicant.
ನೀವು ಹೇಳೋದನ್ನ ಅವ್ರು ಹೇಳ್ಬಾರ್ದು ಅಂತ.
ಅಲ್ಲ.
ಆಯ್ತು. Yes. Then the counsel for the petitioner submission. The petition is rendered. File a memo to that. File a memo. File a memo. Dismissed as the same is. He has already cast his vote pursuant to the interim order granted. So election result declare agida? Agida.
Please.
Declare.
No, not declare, my lord, lordship, my lord, direction.
Related to declare. Yeah, respondent number?
Respond number, my lord, 5.
Returning officer.
Please, sir, please.
Yes.
Lord, 7 and 8 also, my lord, the same matter pertaining to.
Dispose. In view of disposal.
Serial number 7 and 8, my lord, same matter pertaining to the serial number 2 is concerned. 7 and 8, adu same. Tav KPID dene, adu na avataku.
7 and 8 tomorrow listed.
Monday, adu regarding second matter, my lord, second iruttare, same matters.
Serial number 2 yavaga ಆಗ್ತಿರೋ ಅವಾಗಲೇ. 7 and 8.
Also same.
Yes.
8 also same.
9. Anil Kembave.
Please, I appear for appellant, my lord. This is the, my lord, defendant's appeal against the divergent finding of the
Then dismissal agida.
suit is for easement
RSA
right.
is already dismissed.
Please, I have filed an IA. The applicant have filed an application for recalling of
Application ಹಾಕಿದ ಕೂಡಲೇ allow ಆಗಲ್ಲ sir. Application will also be dismissed.
the application I have filed. Not intentionally, my lord, the non-appearance is non-intentional.
Effect is the same sir, whether intentional or not.
I have set out immediately I have filed application.
Will not hold an inquiry whether it is intentional or not. The result is the same. You have not addressed the argument.
Correct. The non-appearance is I admitted. Non-appearance, but I filed an application.
ಯಾವಾಗ argue ಮಾಡ್ತೀರಿ? ನಾಳೆ?
ನಾಳೆ ಅಥವಾ next.
Day after tomorrow. Personal inconvenience. Tomorrow.
ಅಲ್ಲ, day after.
Friday.
ಅಲ್ಲ, ಫ್ರೈಡೆ ನಾನು ಇರಲ್ಲ, ಊರಿಗೆ ಹೋಗ್ತೇನೆ. ಮಂಡೇ ಅಲ್ಲ, ಮಂಡೇ ಅಲ್ಲ, ಅಥವಾ ನಾಳೆನೇ ಇಡ್ಬೋದು.
ನಾಳೆ you argue, Friday ನೀವು ಮಾಡಿ.
Yes, tomorrow I will argue, please. Because Monday ನಾನು ಇರಲ್ಲ, Friday ನಾನು ಇರಲ್ಲ, ಊರಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ.
Thursday or tomorrow?
Thursday, tomorrow I will argue. Tomorrow, please.
10. KV Narasimhan.
Please.
G Manivannan.
filed the application.
Non-furnishing of details.
Weeks time may be granted.
ಯಾರು ನೀವು ಕೊಡ್ಬೇಕಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಯಾಕೆ ಏನ್ ಡಿಫಿಕಲ್ಟಿ ನಿಮ್ಗೆ?
ಅದು ಡಿಫಿಕಲ್ಟ್ ಏನಂದ್ರೆ ಫಸ್ಟ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ಸ್ ನ ಜಯರಾಮ್ ರೆಡ್ಡಿಗೆ ಇಬ್ರು ಹೆಂಡತಿಯರು.
ಅಲ್ಲ, ನಿಮಗೆ ನಿಮ್ಮ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ರೆ
ಅಲ್ಲ,
ಅಪಲೆಂಟ್ ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಪಲೆಂಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ ಸರ್, ನಿಮ್ಮ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಯಾರು ಅಂತ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾವು ಕೊಟ್ಟಿದೀವಿ, ಪರ್ಮಿಟ್ ಮಾಡಿದೀವಿ.
Last date ಅಲ್ಲಿ they have said that they'll furnish.
ಎಲ್ಲಿದೆ ಕೊಡಿ ನನಗೀಗ.
ಅಲ್ಲಲ್ಲ, ಇದರಲ್ಲಿ
ಕೊಟ್ಟಿದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕಲ್ಲ ಡೀಟೇಲ್ಸ್.
ಅಲ್ಲ ಅವರು ಡೀಟೇಲ್ ತಗೊಂಡಿದ್ದೀನಿ,
ತಗೊಂಡಿದ್ರೆ ಕೊಡ್ಬೇಕಲ್ಲ.
ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ. ಅದೇ ಒಂದು
ಮತ್ತೆ
ಅಪ್ಲಿಕೇಶನ್
ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಯಾಕಂತೀರಿ?
ಅಲ್ಲ ಸೈನ್
ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಯಾಕಂದ್ರಿ?
ಅಲ್ಲ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳಲಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದೀವಿ ನಾವು ಡೀಟೇಲ್.
ನನಗೆ ಕೇಳಿದ್ದು ತಪ್ಪಾಯ್ತು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಅವ್ರಿಗೆ ಆಪೋಸಿಟ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರ್ ಸಿಂಪಲ್ ಆಗಿ ಕೊಡಿ ಸುಮ್ನೆ.
ಆಯ್ತು ಸ್ವಾಮಿ.
ಹ್ಯಾವ್ ಯು ಕಲೆಕ್ಟೆಡ್ ದ ಡೀಟೇಲ್ಸ್?
ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಇನ್ನೂ ಮಾಡ್ಕೊಂಡಿಲ್ಲ?
ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು.
ಇನ್ಫಾರ್ಮೇಶನ್ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆ ಸ್ವಾಮಿ.
ಕೊಡಿ ಅಲ್ಲಿ. ಸೈನ್ ಮಾಡಿದೀರಾ ಅದಕ್ಕೆ? ಸೈನ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮಾಡಲ್ವಾ?
ಇಲ್ಲ ಮಾಡ್ತೀವಿ.
ಹ್ಮ್.
ಅದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ನಾವೇ ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಜಿಯೋಲಾಜಿಕಲ್ ಟ್ರೀ ಇದೆ, ಒಬ್ರದ್ ಮಾತ್ರ ಡೀಟೇಲ್ಸ್ ಇದೆ. ಸೊ ಇವ್ರೊಬ್ರೇ.
I'll post it on Friday. You have to furnish the details. Counsel for respondent submits that he has collected the information regarding the legal representatives of deceased. Yaru?
Respondent number.
Adu gottilla.
There's only one
Respondent. And that he will furnish the details by Friday. List on. Yes.